Much obliged. Your Honor. Now, I'd like to mention one unlisted bail matter, Your Honor. This matter was listed on Monday. However, due to paucity of time, the matter couldn't be taken up on. So,
It
kindly,
will be listed on Monday.
you know,
Monday, not today.
Dicto President.
Matter number 1.
Yes.
This is a matter in which there was a PIL which was already withdrawn.
Mhm.
Sorry, my lord, a plaint which was already withdrawn. In the withdrawn plaint, an injunction order has been passed.
Right.
My lord may come to the additional affidavit. I'm sorry, my lord, in the main CRP,
Where is the withdrawal order?
a withdrawal order from page 55 to 57.
I'm referring for the respondent in this case. There's a caveat file.
Okay. So, you are appearing for all the caveators?
Yes, please.
Yes, ma'am.
Appearing for all the caveators, yes.
Minor.
Yes, page?
Page 55, my lord, annexure 7.
Annexure 7.
Ma-
Yes.
Heard so and so. The plaintiff has filed an interlocutory application praying for through learned counsel so and so, praying for withdrawal of the plaint. On perusal of the application and upon hearing learned counsel for the parties, it is evident that the plaintiff seeks to withdraw the suit unconditionally. Withdrawal of the suit is governed by Order 23, Rule 1 of the Code of Criminal Procedure 1908. Under Order 23, Rule 11C, Rule 11 of the CPC, the plaintiff is at liberty to withdraw the suit at any time. Where the plaintiff seeks withdrawal without liberty to institute a fresh suit on the same cause of action, the withdrawal results in termination of the proceedings. And the plaintiff is ordinarily precluded from filing a fresh suit on the subject matter in view of Order 23, Rule 14 CPC. In the present case, the plaintiff has not sought for permission to file a fresh suit on the same cause of action, nor has any ground been made out for grant of liberty under Order 23, Rule 13 CPC. Accordingly, the prayer is treated as a prayer for simple withdrawal. At the same time, this court cannot be unmindful of the fact that the institution and continuation of a civil suit necessarily consumes valuable judicial time and also burdens the opposite parties who are required to contest the proceeding. Further, in the present matter, the court has already been called upon to pass interim orders and interlocutory proceedings were taken out by the parties. In such circumstances, it is well within the discretion of the civil court to impose reasonable costs while allowing withdrawal so as to advance the ends of justice and discourage abuse of the process. Considering the overall...
So some cost was given?
Yes,
it was withdrawn.
It was withdrawn. We have deposited the cost.
Cost was imposed on?
It was imposed on the plaintiff who had withdrawn.
Yes. Then what happened?
Thereafter, my lord, the present respondents, they have filed a miscase from page 58 to 74.
58?
58 onwards.
74, they filed a miscase.
They filed a miscase.
What is the prayer?
My lord. The prayer, my lord.
And miscase is filed under...
There is no...
Order 39, Rule 1, 2. Okay.
Yes, my lord. My lord. The prayer is at page 70, my lord.
Page 70.
In the premises aforesaid, it is therefore respectfully prayed that Your Honor may be pleased to issue notice calling upon the respondents as to why the declaration of qualified candidate list dated 24/1/2026 and the declaration of election result, whereby it is shown the list of elected unopposed candidates of various central executive members of ADISU for the session 2025-28 shall not be set aside and quashed and declared void ab initio. And in the interim, Your Honor may be pleased to stay and suspend the declaration of qualified candidate list dated 24/1/2026 and declaration of his election result, whereby it is shown that the list of elected unopposed candidates of various central executive members of ADISU for the section 2025-28 for the interest of justice. Now, my lord may come to the memo.
So they have basically paid for, there are certain candidates who were basically uncontested.
Uncontested.
And they say that uncontested members should be allowed.
My lord.
That was their prayer, right? They should be allowed to hold the office. Since they have been declared uncontested. So that was their limited prayer.
That was limited.
Limited prayer, but only thing is that your contention is that how can, in a disposed matter, mistakes can be. So you have any judicial pronouncements where it has stated that after disposal of a case, That miscase cannot be
My
filed.
lord, there is another factor. If my lord comes to page 58,
58. Yes,
the memo of parties,
yes.
1 and 2 are the applicants.
Mm.
Then, my lord, in the matter of from page 59, there are 9 contemners or violators. Then, my lord, may come to page 60.
Mm.
In the matter of the plaintiff Jirmo Jamo versus number 1 is Adi Bane Kebang, 2 is Tajum Tapo, 3 is Nyapa Rinia, 4 Gomle Ratan, 5 Monu Ratan, 6 Parem Payung, 7 Omit Ratan, 8 Abang Ratan, 9 Talok Tayang, 10 Tium Payung, 11 Gotem Tayang, 12 Putte Tayang. My lord, the miscase has been filed, the Order 39 application has been filed against 2 persons who are not parties to the suit. So without impleading them as parties in a withdrawal, in a withdrawn matter,
No, they were not party in the
suit,
which has been
disposed of
on withdrawal.
Yes, my lord. Now, in that they have filed this Order 39 application. Now, my lord, if my lord comes to the provisions of Order 39,
Mhm. Yes, Order 39.
yes, my lord, my lord may come to Rule 2.
Hmm.
Rule 1 is, my lord, is in case of
Temporary.
property and all.
Hmm.
Rule 2, my lord, injunction to restrain the reputation or continuation of breach in a suit for restraining the defendant from committing a breach of contract or other injury of any kind, whether compensation is claimed in a suit or not, the plaintiff may at any time after commencement of the suit and either before or after judgment apply to the court for a temporary injunction to restrain the defendant from committing a breach of contract or injury complained of, or any breach of contract or injury of the like arising out of the same contract or relating to the same property or right. 2, the court may grant by order grant such injunction on such terms as to the duration of the injunction, keeping in account giving security or otherwise as the court thinks fit. My lord, here, Order 39 application has to be filed by the plaintiff. In this case, they were not the plaintiffs, and neither was I a defendant. So, Order 39 could not have been resorted to. And if my lord sees the injunction order at page 75. Sorry, my lord, it starts at page 74, my lord.
Yes.
The miscellaneous application has been filed by the applicants under Order 39 Rules 1 and 2, read with Section 151 of the Code of Criminal Procedure, seeking stay of the declaration of qualified candidate list and the declaration of election results dated so and so, whereby list of elected unopposed candidates of Adi Students Union for the session 25-28 has been published. My lord, the case of the applicants in brief is that there was a subsisting interim injunction passed by this court on 22/12/25 in title suit number 11 of 25, disposed of on withdrawal Wide order dated 4/2/26, restraining the election process of Adisu, which was within the knowledge of the election authorities. It is alleged that in deliberate disregard of the said injunction order, the election process was clandestinely proceeded with during court holidays, culminating in declaration of qualified candidates and unopposed election results, thereby rendering the election process illegal, void ab initio, and non-est in the eye of law. Heard Mr. So-and-so. For the applicants, peruse the application, annexures, and record placed before the court. At the stage of considering application under Order 39, Rules 1 and 2, CPC, the court is required to examine three well-established, well-settled parameters, namely, existence of prima facie case, balance of convenience, likelihood of irreparable injury. From prima facie perusal of the record, it is evident that an interim injunction order dated 22/12/25 was indeed in force, restraining the election process, and that declaration of qualified candidate list dated 24/1/26 and election results dated 25/1/26 were made during the subsisting existence of the said order. Whether such acts amounts to willful disobedience or whether any justification exists are matter that required adjudication after hearing all concerned. However, at this stage, the applicants have been able to make out a prima facie case warranting protection. The balance of convenience also tilts in favor of maintaining status quo in the election. If the election results are allowed to operate pending adjudication, it may lead to creation of equities which may ultimately defeat the very purpose of the pending proceedings. As regards irreparable injury, it is well settled that once an election process conducted in alleged violation of court order is allowed to take effect, the injury caused cannot be adequately compensated in terms of money and would strike the sanctity of judicial orders. This court is also conscious of the fact that judicial orders are not empty formalities and must be obeyed in letter and spirit. Any act done in the teeth of subsisting court order cannot be permitted to gain legitimacy merely by passage of time without expressing any opinion on the merits of the case and strictly for the purpose of interim protection. This court is of the considered view that the applicants have satisfied the requirements for grant of temporary injunction. Accordingly, operation of the and effect of the declaration of qualified candidate list dated 24/1/26 and declaration of election results dated 25/1/26 pertaining to Adisu election for the session 2025-28 are hereby stayed suspended till disposal of the miscellaneous application or until further orders of the court. Issue notice to the respondents to show cause as to why the interim order shall not be made absolute. Next, returnable suens.
Yes.
Application to take steps. My lord, here, first requirement is that Order 39 can be resorted to only by the plaintiff against the defendant. Here, neither was the applicant, were the applicants in this application, this case, were plaintiffs, nor was I a defendant or even a party.
So they were not a party to the
They were not parties.
to the earlier suit.
Yes, my lord. So Order 39 could not have been resorted to. Then, my lord, second leg, my lord, is that Order 39 is in pending application, pending suits. Here, my lord, the suit was already withdrawn. When the suit is withdrawn, insofar as passing of interim orders, in my humble submission, the court would become functus officio. Therefore, my lord, this order could not have been passed. And passing of this order is a nullity. Since it is a nullity, my lord, I cannot take recourse to other matters. Now, here, from the respondent's side, it may come that there is a remedy of appeal against orders passed under Order 39. My lord, I am not a party to the suit. Therefore, my lord, to prefer an appeal, I cannot be an aggrieved party because I was the election commissioner and the returning officer.
You are appealing for whom actually?
The election commissioner and returning officer.
Election commissioner, returning officer. Election commissioner, returning officer. They were not a party.
They were not parties.
Party there.
My lord.
Now this case has been filed by this Kebang, right?
My lord. It was a suit between the former president of Adisu and the Kebang. The Kebang, my lord, the students.
So election, because at that point of time, I mean, there was no election officer probably, correct? Or it was there.
It was there, my lord. It was there.
So election commissioner was not made a party. Election commissioner or election what? Chairman of
Commissioner.
So
Election
he was not made a party. Now this application has been filed by Tajum Tapo
Yes,
and
my lord.
Rinia.
My lord.
So Tajum Tapo and Rinia are who?
They were impleaded parties.
Huh?
They got themselves impleaded, my lord. They were contesting candidates.
They got themselves impleaded in the suit.
In the suit.
So
in
that,
the suit.
so that means they were a party there.
They were parties. They were impleaded as defendants in the suit.
Defendants.
Defendants. Order 39 can be only on application by the plaintiff.
Okay. Okay.
They are not parties. My lord, they are not contesting candidates. They belong to the Siomi district unit of Adisu, but not candidates.
So what was their Locust Standi to file this?
Because they belong to one district unit of the
One district unit of
one district unit.
So in this Adisu is the state organization.
It's a students' union
Covering the state.
covering all the 6 districts, my lord.
6 districts.
6 districts. And my lord, there is a central executive and the district units.
So
These two,
these two persons are one of the district units,
my lord, they belong to one district unit.
one district.
One district unit,
And their basic contention is that since election has happened,
my lord.
but election happened during the injunction. I mean, there was
My lord,
there was
before
an
that,
interim order,
there was an interim order.
Interim-
Before that, the election was supposed to take place.
but interim order was passed not to hold the election,
Yes,
to hold the election.
yes, my lord.
Then, but in spite of that order, election was held.
My lord, this order was not served on the persons who are presently before lordships. On the election commission, returning officer, it was not served. We came to know, my lord, from social media. So thereafter, we said, if there is an order passed, let us not hold the election. But till that time,
No, but thing is that like before this court, I mean, there's only one issue that like, whether this application is maintained in the
my lord,
before, I mean, before this court of civil judge,
civil judge,
whether the order was wrongly passed or rightly passed.
with jurisdiction or without.
So your argument is basically that it, I mean, other than the applicant, nobody could have filed this.
Yes, other than the
Because-
plaintiff,
Other than the plaintiff, because this suit is already disposed of.
so, my lord,
Correct. And
My lord.
now, but it's order 39 rule 2, if
My
we
lord.
read,
my lord,
we have already read,
my lord,
but it says at any time after commencement of the suit
my lord,
and either before
my lord,
or after judgment.
my lord, my lord.
So what does it mean? I mean, does it mean that after the judgment also miscase under a miscase under order 39 rule 2 will be,
My lord, after that.
but it says in any so and so
Made
in
both
restraint
either before or after judgment.
judgment.
My
So,
lord, my lord,
so in your case,
in my case, my lord,
Hmm.
it was after withdrawal. The suit is not there.
Hmm.
The suit is not in existence. And my lord, after judgment, it
Hmm.
will be for execution. My lord, to restrain breach of contract. My lord may read thereafter, apply to a court for temporary injunction to restrain the defendant.
Hmm.
It is only against defendant.
for committing
Breach of contract or injury complained of,
Hmm.
or any breach of contract or injury of a like kind arising out of the same contract or relating to the same property or right. My lord, the original plaint was against some resolution of the Kebang.
Hmm.
So this was not there before the court at that time. And it is only by the plaintiff and to restrain the defendant, no one else.
So your case is that like, I mean, these two people were not there.
They were not there.
They were not the defendants. also.
They were not defendants and neither was the applicant in the miscase a party. Sorry, my lord, a plaintiff. So therefore, the basic premise on which Order 39,
But recently, I mean, in 2024, I think there is a judgment from the Supreme Court,
my lord,
wherein Supreme Court has, Honorable Supreme Court has discouraged this trend of this miscellaneous application.
Yes, my lord.
Entertaining miscellaneous
Yes.
application
Yes.
after the suit is disposed.
Yes, sir. Yes, my lord. It was in the light
But
of,
that was in the context of a Supreme Court judgment, probably.
it was, my lord, in the case of, I'll get the case, my lord. It was sort of miscases or IAs were filed in, my lord, as applications were filed as miscase or IA, but actually meaning for a review, when review was not permissible. Probably that is the case lordship is referring
Yeah,
to.
maybe that is.
Yes,
the
my
case.
lord.
I've seen some
So
of
that was discouraged. That was in 2024.
them.
I'll get the name, my lord. That judgment, that is there. So, my lord, from the respondent side here now, it may come up that there is a remedy of appeal. Now, appeal, my lord, I am not a party. And neither can I be said to be an aggrieved party. So this appeal under Order 43,
No, appeal will come only when the order is passed by the civil judge
my lord,
in a legal manner.
yes, my
As
lord,
per the law,
with jurisdiction, under jurisdiction.
which jurisdiction. If the order itself goes, then there's
Yes.
no question of
Exactly, my
appeal or something like that.
Exactly, my lord.
So the, I mean, the what the court needs to examine is that whether that order was passed correctly or not.
My lord,
And once it is, it is held by the court that the order was passed correctly,
My lord.
then the question will come whether what are the options
Yes.
available.
Yes, my lord.
Correct?
Yes, my lord.
So that has to be seen. Okay, you have anything more to say?
My lord, this is basically the long and short.
Let us hear
My-
Mr.
my-
Magimkar.
May it please, Your Lordship.
Yes,
And my first submission is, Your Lordship has seen from the application the respondent has filed, which is available at page 58. The order was passed in an application under Order 39, Rule 1 and 2.
yes,
And my lord, any order passed, either ex parte or ad interim or final, Supreme Court has made it very clear, my lord, I have brought that judgment also, that only appeal lies, no revision lies. So in that view of the matter, the present revision petition under 115 is barred. Whatever grounds they have to take on merit, they can urge only before the appellate court, my lord. Lordship, may kindly have a look at Order 43, Rule 1R. my lord.
order 43.
Rule 1R. Order 43, if your lordship has got none.
Yes, order 43, rule 1.
One says appeal from orders. An appeal shall lie from the following orders under the provisions of section 1054. Namely, there are so many orders against which appeal lies, my lord. Are, lordship will kindly see, relevant is are an order under Rule 1, Rule 2, Rule 2A, Rule 4, or Rule 10 of Order 39. So in that view, the matter, my lord, present revision application is not maintainable. There is a judgment. My lord, I am relying on judgment directly on the point, my lord. This is
First of all, Mr. Majumdar, I mean, we'll have to see, I mean, whether the order which has been passed by the civil court is
My lord.
correct or not, whether he had jurisdiction to pass that order or not. If it has been passed correctly,
my lord.
then there is then of course that I mean that the question of maintainability of this petition will come. The first
Right.
we'll have to examine whether it was rightly done or not wrongly done, because that is the main contention. That
My
once
lord,
the suit is disposed of,
my lord.
and misapplication filed by somebody who was not a party to the case, whether it is maintainable or not, whether that order has been passed with jurisdiction by the civil court.
My lord, with all respect, I'll submit, my lord. If your lordship will have to invoke first the power to deal with the order. The power has been conferred under Order 39, Order 43, Rule 1R. If there is any illegality, assuming there is some illegality in the order, that can be examined by invoking the power under Order 43, Rule 1R. And that is available before the appellate court. If they file an appeal before this, your lordship, then your lordship can invoke Order 43, Rule 1R. Only in that event, lordship can examine whether the order passed by the learned court below, which is the impugn order, is correct, valid, or incorrect. So in order to invoke your lordship's power, they will have to first go to Order 43, Rule 1R. Other than this, my lord, Supreme Court has made it very clear that no other application will lie if the order is under Order 39, Rule 1 and 2. And for that, I'm just relying on one paragraph of one judgment, which my learned friend has given, my lord. 2000, Volume 7, SSC, page 679. Lordship may just have a look.
2000?
2000, Volume 7, SCC 695, A. Venkatasubbiya Naidu versus S. Chellappan. Lordship, I have given the book list, man.
Yes.
Lordship, may kindly see para 10.
Yes.
Well, para 10 says section 104 of the code says that an appeal shall lie from the following orders and save as otherwise expressly provided in the body of this code or by any law for the time being in force from no other orders. Any order made under rules from which an appeal lies is expressly allowed by rules. Order 43, Rule 1 says that an appeal shall lie from the following orders under the provisions of section 104, namely, we are concerned with R, this is also R. An order under Rule 1, Rule 2, Rule 2A, Rule 4, or Rule 10 of Order 39. Now, Order 39, Rule 1 is quoted here that we can skip, para 13. It cannot be contended that the power to pass interim ex parte orders of injunction does not emanate from said rule. In fact, the said rule is the repository of the power to grant orders of temporary injunction with or without notice, interim or temporary, or till further orders, or till the disposal of the suit. Hence, any order passed in exercise of the aforesaid powers in Rule 1 would be appealable as indicated in Order 43, Rule 1 of the Code. The choice is for the party affected by the order either to move the appellate court or to approach the same court which passed the ex parte order for any relief. Now, in this case, after passing the order, the learned trial court has given them opportunity to file objection, so that by filing an objection, they can also raise whatever objection they have before the learned trial court. Or they're filing an appeal before the learned appellate court, which will be either district judge or learned civil judge senior division, depending on the value of the suit. So these being the position, my lord, the present revision application under 115 is directly barred under the law as well as the judgment passed by Honorable Supreme Court. Second submission, my lord, I'll make before your lordship is, as my learned friend also quite fairly submitted,
Yes.
well, second submission is my learned friend also fairly towards the end of his submissions made a clear statement that the election commission and their officers, they are not aggrieved by the order passed. Yes, some orders in past restraining them earlier to hold election, they have held. Now the court says, I am staying. Now, if there is a stay of the result published by the election commission, the persons who are affected are those who were allegedly elected unopposed. They are the persons who are affected. Election Commission should not be concerned. And your lordship is aware in assembly and parliamentary elections, any order passed and somebody is challenging the result, it is not the Election Commission who passed the election petition. It is the person who is affected. He comes before the court. Now, the persons who are affected, they are not coming directly. They are somehow setting up the officers of the Election Commission, Chief Election Commission, returning officer. They are now before this honorable court. If they are at all interested in saying that no, we want to uphold our order, then they should have approached the learned court below and made filed an objection that see, we have passed the order, somehow we did not have knowledge, etc., etc. And one very interesting thing is, Election Commission is saying that we did not have the knowledge, and in spite of an order specifically passed by the learned trial court in an injunction, in a suit that deferred the election, even after that the election was held. But assuming for the time being, the officers of the Election Commission were not aware, but the persons who participated in the election, they were aware. And can it be assumed that those persons did not have any sort of interaction with the election officers, Chief Election Commission, and thereby the Chief Election can now say that I had no knowledge of the injunction passed by the learned court in the trial court, in the injunction, deferring the election. The election is, my lord, directly in violation of the order passed by the learned court below, and they themselves are admitting it. They are only saying that we do not have knowledge. Even if you do not have knowledge, if you held the election, it was illegal. Now the court has passed an order, as your lordship has seen, that Order 39 Rule 2 says, for the purpose of protecting or restraining someone to breach the order, court can pass even after this disposal of the suit. This is how the court has passed the order. Now, in the present application, the only ground taken is after the disposal of the suit, no order can be passed. But the CPC is very clear. Your lordship has directly pointed out that even after the disposal, court can pass the order, particularly to restrain the breach of the order. Here is also, my lord, the same case. There is a specific order deferring the election in spite of that the election was held. Now, those persons who are the beneficiary of that election, they are not before your lordship even today. They are not before the court below challenging the order. If they are really agreed by the order, they should have immediately gone to the trial court saying that, see, we were also not aware. We have participated in the election, but we were also not aware. And since they cannot say so, the election officers have been set up to file this order, challenge the order by filing the revision application. That your lordship will not countenance, my lord.
Yes, yes. So, Mr. Majumdar, basically you are saying that the order which has been passed by the civil court, that is within the jurisdiction, there is nothing wrong in that order.
This is submission number 1. And second is, my lord, Even if they want to challenge that order, they have
That
to
can, that
file
has
an
to be in
appeal.
appeal, by way of appeal, not by review.
Appeal. And thirdly, my lord, the officers of election are no way aggrieved. My learned friend also very fairly submitted that they are not aggrieved. If they are not aggrieved, why they are challenging? In no election process, my lord, the officers of the election challenge any order passed by the court because they are not concerned. They have done their duty. They have completed their job. Now it is for the parties who are actually aggrieved by the any order passed by the court to challenge that order. They are not aggrieved. They have performed their duty and their job is over. Now, there, if anybody is aggrieved, they should go to court. How can they come before the? They have got absolutely no locus to file this revision application. Maybe they are parties before the court. They have to keep quiet because they have done their job. So, in view of all this, my lord, the present revision. My first submission is present revision application is not maintainable. My second submission is the petition is not maintainable also on the ground that the persons who have approached this honorable court do not have any locus standi because they are not aggrieved party. They are not at all aggrieved.
And third is that, I mean, there is no illegality in passing the order by the civil court.
Absolutely no illegality, my lord. Lordship has directly pointed out that yes, even after the disposal of the suit also, in order to prevent any of the parties to breach any order passed in between, and what they have done, they have filed the suit. Some orders were passed. Since the order was against them, they have withdrew the suit in order to hold the election. So the whole thing has to be seen, and all these things can be examined by the appellate court if they file a proper appeal before the appellate court, provided the appeal is filed by persons who are aggrieved by the order. And they cannot straightway invoke your lordship's jurisdiction under 115. Your lordship's jurisdiction under 115 is very, very clear, if your lordship goes to that if any order is passed by the court below, which is without jurisdiction or in excess of jurisdiction, there your lordship will interfere. But here is a case, first of all, jurisdiction is there.
That was their first agreement, that order was passed without jurisdiction.
My lord, but then provision says jurisdiction is there. Even after disposal of the suit, they will have to satisfy. Then in spite of that provision, your lordship is pointed out. I need not point out, my lord.
And that is why we are asking the council to submit any judicial pronouncement they have.
Yes, my lord.
To
Judicial
contain
pronouncement.
their argument.
My lord, the judicial pronouncement is rather against them. And there are two other judgments. I didn't want to bother your lordship. There is one judgment of Surya Devi, which says after the amendment of the CPC in 2002, what is the jurisdiction of the court? Earlier, my lord, the provision was any order passed by the court below, a revision used to be filed. So, in order to protect the parties from prolongation of a matter, CPC was amended for early disposal, and thereafter all revision such revision petitions are barred. Now only persons who are covered by the proviso of section 115, my lord, can come before the Supreme Court under 115. Otherwise not. Your lordship is aware of that, my lord. So that being the position, my lord, the present revision, no relief is entitled. If your lordship desires, my lord, I can file a detailed affidavit. Lordship may take it up after 2 weeks. I'll file an affidavit bringing all these materials. My lord, admittedly, the election was held in violation of the court's order. My lord, difficulty here is they have, my lord, I'm not on the election, etc., but otherwise, their constitution itself says that the post of president will be by rotation district-wise. So this time, by rotation, it was for Shiomi district. But somehow, my lord, there is a dispute between the students that no, it should be for Namsai. So from Namsai, there is an effort to bring someone from Namsai. But under the rotation system which they have adopted so far, it is the Shiomi district. And our clients are from Shiomi district. And there was a resolution passed that yes, it will be from the Shiomi district. They have first challenged the resolution, my lord. There was an injunction. Subsequently, when we went and filed an application for modification, that order was modified, saying that yes, there will be stay of that resolution, but please do not hold the election now. Let us examine. It is deferred. Now, in violation of that order, election was held and suit was withdrawn. So everything is, my lord, not quite fair and legal, my lord. So, lordship,
Okay,
if your lordship,
Mr. Majumdar, that's all?
yes, ma'am.
Yes, Mr.
My lord.
You have anything?
My lord,
from my learned senior submission, well, towards the end of my learned senior submission, submitted that the remedy available to me would be that of an appeal if I am aggrieved, if I'm a person aggrieved, because it's only a person aggrieved who can file an appeal.
Yes.
Now, my learned senior submission is, I am
Learned senior counsel has submitted that
Right.
you are not aggrieved but
Not-
at all.
not a person aggrieved to prefer the appeal.
Mm.
Now, my lord, there is a maxim, ubi jus, ibi remedium. When there is a wrong, there
No,
has to be a remedy.
but why do you want the remedy?
My lord,
Yes.
the reason being this order is passed against me. I am made the opposite party in this miscase. Now, the relief which they seek, my learned senior has rightly pointed out that in election petitions, this is not an election petition. In election petitions, it is only the parties to the election, the candidate or someone on his behalf, my lord, if he is a voter, they can file. And it is the Representation of People's Act is very clear as to who can be the parties. Now, in this case, the contention is that the persons who would be affected by the outcome of the election are not there in the miscase. Neither in the suit nor in the miscase. My lord, in that event, if they are also not aggrieved, this order will attain the finality if it is not interfered with, my lord. It is against non-parties to the main issue at hand, and orders are passed, and it cannot be appealed, so therefore it attains finality.
No, only, I mean, like, I mean, we have a small query.
My
I
lord,
mean, I have a small query.
my lord,
I mean, the election I mean, you are the election commissioner, right? Election commissioner and
and returning officer.
returning officer. Now, how you are affected?
My lord, because I have to carry out the orders.
Which orders?
The order restraining the election, the order in which, my lord, the order has already been, the
Court has passed an order.
My
You-
lord.
You were not a party there.
my lord,
Now order has been passed by court and
My
how
lord.
you are aggrieved?
my lord. That is why, my lord, I cannot be a person aggrieved
No. For filing this also, how
My-
you are aggrieved?
because I have to carry out the order passed, my lord. The election process has been stalled. If the election process is stalled, my lord, I have to carry out a fresh election.
The fresh election, that issue will come later on,
My lord,
once it is decided.
Yes, my lord, if it
But-
is
but what
decided.
is, I mean, what you will do there? How you are aggrieved?
Because, my lord, my role as election commission and returning officer,
Yeah, I mean, you want to stall the election, you want,
the results are already out.
then,
My lord, they have not challenged the results of the election.
no, if the elections have been already declared,
My lord,
you were the commissioner there.
yes, my lord.
Now, what do you want from the court?
Because, my lord, the reason why I am before lordships, that's a lordship has very rightly made this query. Because why I am before lordships, my lord, my role as election commission is to see that the election is done in the
It
proper
is already
manner.
done,
It is already done. The election results are declared,
declared.
already done.
Correct.
Now, my lord, after that, if this restraint is there,
Now there is a restraint order.
my lord,
A restraint order, you should abide by the restraint order.
my lord, the
And let the candidates fight out if let the aggrieved party fight out.
my lord,
If there
in
is
that,
something, if the order is wrongfully passed,
My
then
lord.
the aggrieved party will go.
My
You are
lord,
not affected.
yes, my lord,
order.
yes, my lord. The aggrieved parties have not been made parties.
No, aggrieved party can always go to the civil court and file an impeachment petition to make themselves party.
My lord,
They can do that.
Exactly, my
yes,
lord.
my lord. My lord, before that, my lord will see Rule 3 of Order 39.
Rule 3 order
Rule
39.
3
Okay,
order.
Rule 3 order 39. What does it say? One second.
My lord, my-
Yes, Rule 3.
my
Yes.
lord. Before granting injunction,
Hmm,
court to direct notice to opposite party.
hmm.
The court shall, in all cases, except where it appears that the object of granting the injunction would be defeated by delay, before granting an injunction, direct notice of the application for the same to be given to the opposite party.
Hmm.
Provided that where it is proposed to grant injunction without giving notice of application to the opposite party, the court shall record reasons for its opinion and that the object of granting injunction would be defeated by delay and require the applicant to deliver to the opposite party or to send to him by registered post immediately after the order granting injunction has been made a copy of the application for injunction together with copy of affidavit, copy of plain, copies of documents on which the application relies. And B, to file on the day on which such injunction is granted or on the day immediately following that day, an affidavit stating that copies there aforesaid have so been delivered or sent. So, my lord, the mandatory requirement is notice. And my lord, the proviso there is if notice, if the purpose, purport of the injunction would be defeated by delay, then it can be an ad interim injunction can be
No,
granted.
I mean, got it. Now, if there is some violation in passing the order, you have a forum.
My lord, here,
You
the
have a forum. So now
Yes.
is that whether in the, I mean, the primary contention of the senior counsel, Mr. Majumdar,
my lord,
is that this revision petition, this petition itself is not maintainable
my lord,
because it is barred by Rule 43.
my lord.
Order
My lord,
43 rule 1R.
Order 43, Rule 1R.
Order 43 Rule.
My lord. My lord, here, the thing is, it is a person aggrieved who can prefer the appeal. As pointed out by my learned senior, the submission of my learned senior was, they can file an appeal.
Person aggrieved means it covers not many people.
My lord.
It will cover the person aggrieved means, I mean, the candidates also.
Absolutely.
Yes,
The
my lord.
candidates also could have opposed this.
Yes, my lord.
Yes,
filing an
yes.
application.
Yes, my lord.
Then matter would have been different.
I'm fully agreeable to that.
Correct.
But my lord, the contesting candidates are not parties to the application.
No, correct. But still, if they are party aggrieved by
They-
their order,
yes,
it's still
My lord, they have to prefer a leave. They have to prefer the leave and thereafter appeal.
Yes. So,
Yes.
but if on the face of it,
My lord.
if it is barred by Rule 43,
My lord, order for,
Order 43,
My lord.
Rule 1,
my lord.
then how can this be maintainable?
My lord, that is because it is in a pending suit.
Let's see, your Mr. Nair,
My lord,
your two grounds are that one ground was obviously like, I mean, you said that after the disposal of the suit,
my lord,
that injunction could not have been granted
My lord.
by on the basis of the miscase file.
My lord.
Right.
my lord,
That is there, and
My
that you have pointed out this, I mean, Order 39, Rule 2.
my lord,
Correct.
my lord.
Now, rule.
It is by the plaintiff against defendant.
Correct, the defendant, but here, I mean, anyways, that is one thing that is for the interpretation.
My-
I mean, another thing is that it has been pointed out that any order passed under Order 39, Rule 1 and 2,
My lord,
that can be challenged only by way of an appeal.
my lord, in pending suits.
Correct.
My lord, in pending suits.
No, I mean, the thing is that now, what do you mean by pending suits?
My lord,
Where, I mean, see, here it says either before or after the judgment.
That is after. My lord,
So judgment means if the case is disposed of.
my lord,
It covers any case if whether it is withdrawn or it
Yes.
is or it is dismissed on merit
Yes,
or
yes.
allowed on merit.
yes, my lord.
Correct.
So
So that will cover that.
that will cover.
That will cover.
That
So
will
in
cover.
your case, you are saying that was already withdrawn.
My-
So if the withdrawn means the case, I mean, the order is already finally passed.
My lord,
It
my
is
lord,
disposed of.
my lord,
Disposed of on withdrawal.
my lord.
So there is no, I mean, case. And in this order, in this Rule 2 also,
My lord.
it covers the same thing. It covers the case, your case. So
My lord,
that,
my
that
lord,
was,
may-
that will look into,
My- My
I'm not, I mean, saying that you don't have any force in the argument. But secondly, that mandatory notice thing you are arguing,
my lord.
that the notice would have been given.
Given
But-
to the opposite parties,
Correct.
the opposite parties who would be the persons aggrieved. Here, they have very, my lord, cleverly not made the parties who would be aggrieved as parties to the missed case. And that too, they ought to have filed a separate suit if required. They have not done that. The suit, my lord, would be on a cause of action. This cause of action was not there when, my lord, the suit was filed, when the plaint was filed. And the suit was withdrawn before that.
So like we can do one thing where Mr. Nair, I think I have heard, I mean, both of you, let them file an affidavit, detailed affidavit, but no interim order can be passed.
My lord, the reason why that interim would be required, my lord, is, my lord, order 43, Rule 1R, that would be,
That will be considered,
My
those
lord.
arguments will be, I mean, heard again,
My-
because it will need some consideration.
my lord,
Let them file an affidavit. I mean, we'll fix maybe on a short date. but that matter has to be, I mean, these things has to be heard. And
My-
because all these things are really legal issues,
My lord.
a court will require some time, not at the motion stage.
My lord,
So we will hear you, but
My lord.
at this stage, we will not give you any interest.
my lord, they got the interim order, my lord, without jurisdiction. So here what
No.
I am on, my lord, lordship will examine the
I'm
matter.
not, I'm not convinced that order was totally out of, totally without jurisdiction.
My lord, the reason why, my lord, is if lordship is on after judgment. After judgment, if lordship reads the words just after the word after judgment. If lordship once again just comes to that.
Yes.
My lord,
See,
anytime.
it has given, this rule has given wide enough power to a civil court.
yes,
Taking into the contingencies that may evolve there.
yes, my
Okay,
lord, yes, my lord,
So what it says,
my lord.
in any suit for restraining the defendant
Defendant, my lord, that
from
is one.
committing a breach of contract or other injury of any kind. So other injury of any kind
Any
covers
kind.
lots
Yes,
of
madam.
things,
My lord,
whether compensation is claimed in the suit or not.
yes, my lord. The plaintiff.
The plaintiff may at any time after commencement of the suit and
Yes.
either before or after judgment apply to the court
My lord.
for a temporary injunction to restrain the defendant from committing the breach of contract or injury
Complained of.
or injury complaint or or any breach of contract or injury of a like kind arising out of the same contract or relating to the same property or right.
Exactly.
So
That is-
Very comprehensive.
so here there is no contract, there is nothing, but there is a right.
There is a right,
So
my lord, of the plaintiff, out of the same contract or kind, of the plaintiff, my lord.
Hmm.
This is,
but here also it's the same issue.
no, my lord, here it is a totally different issue.
How?
And my lord, here, my lord, the suit did not pertain to this election. It pertained to a resolution of the Kebam.
But there was an order of injunction.
That was thereafter. But that was in respect of a separate miscase. In this miscase, my lord, my lord will just once again see, my lord,
No.
as to who can file this.
Hmm.
It can be filed by the plaintiff to protect his rights against the defendant. That is the underlying, my lord, thread, the most important thread of Order 39, Rule 2. It is to be by the plaintiff against the defendant to protect his interest, which is there in the suit. Because lordship, here it is clear, out of a breach of contract or injury complained. In the same contract, it cannot pertain to something else. If that is so, there were some other judgments.
No, here we are not involved within a contract or something.
Not a contract.
It should be an issue,
It should
kind of
be,
matter.
yes, my lord, the same issue which has to be there. Only in that the plaintiff can approach the civil court for an injunction restraining the defendant. Here the plaintiff is Mr. Jirbo Jamo. Jirbo Jamo is not there. So therefore, if Mr. Jirbo Jamo, the plaintiff, is not there, this Order 39, Rule 1 and 2 cannot be applied in case of someone else approaching that court in the disposed of suit for an injunction. If they are aggrieved, my lord, they have to file a proper suit. They would be the plaintiff there, not in this case. My lord, as my learned senior has
Okay,
pointed out,
so you are, I mean, you're basically arguing that this right is given only to the plaintiff.
only to the
A
plaintiff,
plaintiff
against the defendant, no one else. My lord.
Order 39, Rule 2 gives right only to the plaintiff.
Yes.
So let us hear Mr. Majumdar on this.
Yes. My lord, I was just praying for. My lord, my learned friend possibly is not correct in saying that only it is available to the plaintiff. My lord, law is very clear. In a suit filed by the plaintiff, if necessary, the court can pass an order of injunction in favor of the defendant also. Now, if any order is passed in favor of the defendant and there is a violation, who will file the application for preventing the violator? It is the defendant. And therefore, my lord, in the present case, what has happened? Initially, the injunction was obtained by the plaintiff in favor of them. But subsequently, after we appeared, we filed an application for vacating. That order was modified to the extent that election is deferred. This deferment order is in favor of the other side, defendant. And that is why this application at the instance of defendant is necessary, because this rule 2 says in order to prevent breach of order. Now here, the plaintiff who filed suit, they themselves were going to breach the order, and which they ultimately breached also. So since there was a threat of breach of order passed by the court, and which was actually in favor of the defendant, they did two things. They held the election in violation of the order. They withdrew the suit so that no action further can be taken. But now, in view of that, the application by them is maintainable because it is in their favor. We cannot say the minor in a suit only the plaintiff is entitled to an injunction. Even the law is very clear, my lord. Defendant is also entitled to an injunction in a given case in a suit filed by the plaintiff. That is the catch, my lord. So that being the position, the order is absolutely correct. And now they are invoking your lordship jurisdiction where your lordship cannot interfere under this jurisdiction. They have got remedy. Remedy is before the appellate court. Appeal will lie before the court where appeal lies from a decree passed by the learned trial court. Your lordship is aware of that. So in that view of the matter, your lordship may keep it on a subsequent date. We'll file our short reply. Lordship will finally dispose of the matter because if your lordship passes any interim order of stay, the entire relief, final relief will amount to be given to the petitioner, which they are not entitled to even in, because
Well,
the
what I
revision.
can suggest. Sorry.
Yes, now please make a submission.
Yes. Yes, Mr.
My lord, what I can suggest, my lord, is that if lordship passes an interim, because this order is an illegal order. If lordship stays the operation of this order, and lordship may also delay that no other measures be taken. That will protect interests of everyone.
My lord, any
Here, my
order
lord.
passed in this case will go in favor of those who are not before your lordship. And this cannot
My
be
lord,
allowed, man.
My lord, who are before lordships? It is someone who is not a candidate. It is the applicant in the miss case is not someone who is a candidate.
No. You see, before this court, I mean, you are an election, you are a person
They are not
who
at all
has-
aggrieved.
who has held the election.
My lord.
You are not the candidate.
No,
You are
no.
not aggrieved. You are not, I mean.
That is why, my lord, I cannot file an appeal under Order 43.
Now what is the status? Now election has been
Over.
the court has given a status quo order.
My lord.
Let the status quo order remain.
My lord, status quo, no, stay order.
Stay order, let the
Yes.
stay order remain like that.
My lord.
We are not going to touch it because we'll have to see if we touch it, we'll have to touch the whole. I mean, then we'll have to we'll have to show that prima facie we are convinced that it was an illegal order.
My lord,
And-
in fact,
Because that order now. Yes, Mr. Majumdar.
My lord, lordship is absolutely right in saying that your lordship should be convinced that order is bad. Secondly, my lord, which is in my humble submission more important is first your lordship will have to decide when I'm raising the question of maintainability and when the law is very clear. Lordship will have to decide first that this present revision petition is maintainable on two counts. One, the bar under Order 43 Rule 1R, and secondly, the persons who have approached before lordship are aggrieved and they have got locus. They are officials. After the result is declared by them, they are hardly concerned with the result. Their job is over. Now, those who are aggrieved by the order, they will go to the appellate court. They are saying that those persons were not parties. Why are you arguing for them? There are remedies available. They can file an application for imprisonment. They can file a fresh suit challenging this order. There are plenty of ways under the Civil Procedure Code. They are not adopting those remedies. They are setting up the Election Commission to give them relief. That is not permissible under the law, in my humble submission, man.
No, see, Mr. Nayar, like two things. I mean, one is the maintainability that the issue has come up, and like Mr. Majumdar has rightly pointed out, there is an issue.
there is an issue.
There is an issue, that has to be decided by
My-
this court.
my-
That is one issue that has to be decided first. Then secondly, we'll have to examine that whatever the stay order that is passed by the civil court, whether that is correct or not,
My lord,
on the basis of the law available.
my lord.
Correct. Now, both the things, it will require some consideration.
Yes, my lord.
You agree to that?
My lord,
Both
prima
of you
facie,
agree,
my lord, prima facie, it's an illegal order.
Agree to that. Now, if you are saying that like it's an illegal order, Mr. Majumdar is saying there is no illegality in that. So both of you are saying so. And I have also have my own opinion, but
My
like
lord.
I need to consider this.
My lord,
It will take some time because
My lord.
with the process stage, it cannot be.
my lord,
considered.
my lord,
We'll have to consider.
my
this.
lord, my
So
lord.
what I'm suggesting is that like let them come up with an affidavit.
Short
My-
affidavit.
We will not. We sort affidavit. We will not touch anything.
My lord,
Then maybe in the next week,
my
in
lord,
a short date,
my
the
lord.
matter can be decided.
Yes.
Whoever is sitting, if I am
Yes.
sitting, I will decide If somebody else is sitting,
My
somebody else will
My
decide.
lord.
I mean, these are legal issues that has to be
Yes, my
decided. This is not on the facts.
Of course.
That, I mean, immediately we can
Of
just
course.
look into it.
Yes.
Because
Exactly,
it has to be seen.
My
It
lord.
has to be seen. So we'll fix it up in the next week.
What
My lord.
I may suggest another thing, my lord. My lord, this order, because this is an issue which needs to be gone into. Here, my lord, if lordship passes an interim order, staying the operation of this and at the same time restrains the operation of the election, that would suffice. That would,
No, I mean, I'm not in, not in the favor of now touching that order.
my lord.
Whatever order has been passed,
My lord.
it is passed. Now the entire matter will need some consideration.
My lord.
And I think there's a legal issue is involved.
My lord.
Legal issues that you are raising that
My lord.
after title suit was disposed of,
My lord.
whether your case will be covered under Rule 2 or not,
My lord.
or Order 39 Rule 2 or not.
Mine.
You are saying that it will not cover that.
It will not
Right.
cover.
So that, I mean, it is an issue wherein some law has to be said by.
My lord.
Yes.
My lord.
Correct.
My lord.
After interpreting lot many things,
My lord.
after looking to the
My-
laws.
My lord.
So that, I mean, that will require some consideration. So at this point of time,
The-
what I'm suggesting is that
My lord.
I think it will not hamper anything.
My-
It will not do any harm
Yes.
to you also.
My lord.
I mean, if there would have been any harm to you,
My lord.
if you would have been a aggrieved candidate, your result is already declared, but it has been, so that way it is a different thing. But already results are declared now. Only
My-
because it
my
was
lord,
not given
what I-
effect to.
Yes, I understand, my lord.
So what I'm suggesting is that maybe in the next week,
My lord.
My lord.
we'll give them a short time, maybe
My-
7 to 10 days time.
My lord.
My lord.
Then let them come up with
My-
an affidavit, let them come
True.
up with all the laws, then the court
My-
will decide this.
My lord.
Yeah,
Obliged,
I
man.
mean, this court will require some assistance.
Of course, of course, of course.
Both of
My lord, what I would suggest again, my lord, then further proceedings of that miscase, that may not be continued, my lord.
That Mr. Mozumdar, that can be stayed. I think for
Since-
interim,
Since we are before your lordship, that can be done.
that can
but
be
then-
done. I mean, I don't think that will, I mean, that is not on a merit, that only because like this court is entertaining this matter, at least till the further hearing,
My lord.
till the further hearing. So
My-
that miscase maybe, I mean,
My lord, that
Proceedings
operation
of
of
this
that
case-
maybe, my lord.
No, operation of that
no,
order cannot be stayed.
not operation, further
Yes.
proceedings in the matter.
Of the
Yes.
miscase.
Further
My,
proceedings in the matter.
my lord,
That
my
can
lord,
be stayed.
my lord.
That will not harm anybody and that will not do
My lord.
any addition. So what I will do, I'll pass the order in the chamber. I will
My-
just look into a couple of things, then I'll pass the
My-
order.
My
My
lord, my
My
lord.
lord,
But it is sure that like, I'm not passing any interim order.
Yes.
We'll allow you some time to file an
Mhm.
affidavit, and we'll give a sort.
My lord.
And the further proceeding in this case will
My-
be stayed for.
Yes, my lord, my lord.
my
My
lord,
lord,
let clear
lordship-
certain things.
But
My
just
lord,
one,
there is two-
just 1 minute. My lord, I'm praying for 17 subject to what my learned junior says there.
17.
If you-
Could it be 24th, my lord? 15 to 19, my lord, in Aizon, my lord.
The 24th, he's asking, Mr. Mazumdar.
17 in Aizon. Aizon. From Aizon to come to Guwahati. And
Let
if,
it be, let it be 30th, my lord. 30th, I'll be in a better position. 30, Monday, my lord.
30 or if it is 31st, my lord, code number 1, my lord, on 30. If it is
31st, 31st, I
31st
have
or
got a
first,
contesting
or first,
matter.
my lord.
Oh, first is okay. 1st of April is okay.
First,
1st of April.
My lord, my lord.
Right.
hopefully it will not be the day for which it is famous for, my lord.
But only your lordship will kindly make it clear that there is no stay of the impugn order.
But
Otherwise,
no further-
there'll be some confusion by the parties.
No, that I'll make it clear. That's why I'm
Minor,
keeping
minor.
it. I'll
Minor,
pass it.
minor.
I'll
Minor.
pass it in the chamber. Pass it.
My
Minor.
lord, may I kindly clear certain things? There is two application pending. One is for violation and one is for stay. So stay may be, application for stay may be stayed, but the violation proceeding.
Yes,
there is-
No, that's will part of the, I mean, that as far as stay is concerned, that will be there. I mean, that will be considered even in the next day.
But there is also application for violation. We have
Correct.
filed an application under
Madam,
for the 39 rule.
We are
Madam,
not before lordships in
Madam,
respect
you-
of that.
That is different case.
Just a minute. Madam, if I have understood correctly, my learned junior there is expressing his apprehension that there are two applications. The present revision arises out of a particular miscellaneous application,
Correct.
that is number 2. So far as further proceedings of this miscellaneous petition is concerned, that may be stayed. But in respect of other miscellaneous application, Lordship is not staying. That's what my learned friend is saying. And that is not the grievance of the petition also. That's a different
We are not before
proceeding.
Lordship in respect of that case.
Yes,
Other
yes.
miscellaneous petition where? Before the civil court?
Yes, my lord. Yes. That will
That is
continue.
regarding what?
For violation of the interim
Violation.
order.
That will
Okay,
continue.
that's a different, okay.
My
That we are not.
Yes.
Miscellaneous application will clarify that.
My
Will
lord,
clarify that.
my lord, deeply obliged, my lord.
Let me-
Deep
And KBH will be disposed of.
My lord,
discharge.
my lord.
Discharged, sorry, discharged.
My lord,
Correct.
my lord.
Deep.
Item number 2.
Lordship, this civil revision petition, I'm being aggrieved by the order passed by London Civil Judge Senior Division, Daporijo, which was passed in connection with civil appeal number 9 of 2025. The order dated is, the impugned order is at page number 66, Lordship. Now this civil appeal, Lordship, fact of the case is, Lordship,
Civil appeal, which is civil appeal?
page 66, Lordship, is the impugned order. Lordship. I'm aggrieved by this order, Lordship.
Page 60?
66, 66.
Yes.
Now here, Lordship, upon hearing the party for the appellant, Lordship, the Kaba decision which was put to challenge by the respondent was stayed, and the parties was directed to maintain status quo, Lordship. Now before this civil appeal, Lordship, after the Kaba decision was passed, we have filed one caveat. Lordship will find that caveat at the
Caveat was lying there.
lying there.
Then,
That was never heard, Lordship. That is my grievances in this.
but your caveat got expired after 3 months.
Lordship, immediately after the passing of the Kaba decision, Lordship, the caveat was filed.
Caveat was filed, but.
Then
caveat-
thereafter-
But caveat is for how many months?
Lordship, that is of course for
3 months.
3 months, Lordship.
But this order was for after 3 months.
Lordship, but then that
So you did not renew the caveat, or you did not file a fresh caveat.
Lordship,
How can you say that your caveat was still alive?
Lordship may kindly come to page 39, Lordship.
No, you answer me, what is that? I mean.
Lordship, I'm
I mean,
page 39. with-
Factually, it is correct or not?
Lordship, page 39, with page 39, I'll answer. Lordship.
Yes. Page
The
39.
the moment I have filed this caveat, Lordship, after few days, the appeal was filed.
Yes.
Page 39, Lordship will say, see in the
Yeah,
right side of the,
This caveat was filed. Yes, yes, caveat was filed. There is no doubt about this. There is no,
the appeal was filed after few days, Lordship,
yes,
within 1 week of filing of the caveat, Lordship.
yes.
13/10/2025, Lordship.
Where is that date?
Lordship will find it the right side of the page 39, Lordship. This is the appeal filed by the respondent, Lordship.
13/10/2025.
2025.
And you filed caveat on?
On, Lordship, 6/10/2025, Lordship, page
Hmm.
24.
Page 30,
Page 24.
page 24.
Correct, Lordship. Right side, Lordship. Lordship will find the above the seal, Lordship. page-
6/10/2025.
25.
And this appeal was filed by.
The respondent,
Filed by on
13/10/2025,
13/10/2025.
Lordship.
Correct.
Thereafter, this appeal was never taken up, Lordship.
Never
Was
taken
kept-
up for what?
Lordship,
Maybe some defects, maybe some, we do not know why it was not taken up. But it
Lordship,
was not before the court.
it was
It was
filed,
not before the court, because the court did not take up the matter, right?
correct, Lordship.
So that, I mean, you also didn't do anything.
Lordship, we have filed the caveat, they have filed
We
the
have
appeal.
filed a KVA.
Notice was supposed to be served upon me.
Upon in May, serve upon you when? When the matter will be taken up? Or immediately after appeal is filed, notice will be sent to you.
Lordship, whenever the matter is taken up or immediately when the
When the
appeal is,
matter is
appeal
taken
is
up-
filed.
When the matter is taken up, only then, that notice will be given to you, right?
Correct.
Hmm.
Now, Lordship, parallelly, they have filed one title suit also, Lordship. Before, they never appeared before the Kaba, Lordship. And when the ex parte order was passed, Lordship, they filed two applications, in fact, before the proceedings
In
was
a
carried
Kaba,
out.
they did not appear, right?
Correct, Lordship.
And then you, you filed a caveat. Caveat, if the Kaba decision is challenged, then so that you can appear. You are not unheard. So you file a caveat, then they filed a appeal against the Kaba decision.
Correct.
And it was lying there like that, right? It was not taken up
Correct, Lordship.
immediately. Then what happened? They have filed another title suit.
Lordship, that was
Title
Wait.
suit filed before
same court,
the same court.
same court, Lordship. Same court, but then subsequently it was withdrawn, Lordship.
Hmm.
It is at page 65, annexure 5, Lordship.
The title suit they filed forward,
Lordship, on the same dispute matter, Lordship.
but directly they can go to the without going to the Keba, and the Keba without Keba takes a decision without a Keba's decision, whether they can go directly to title suit.
No, so why, Lordship, they have withdrawn this title
Hmm.
suit, Lordship.
Because
By
they,
that time,
because they must have said that they were not aware of the Keba decision.
Lordship, they were aware, Lordship. In fact, they were aware. They
Anyway,
were trying to circumvent the whole process, Lordship.
whatever manner they filed a title suit. Then that title suit, there was no order passed.
Lordship, that was subsequently ordered, no order.
No order passed,
Nothing,
subsequently
Lordship.
withdrawn.
Subsequently withdrawn, Lordship.
And when this matter was taken up, then 3 months time was passed.
Lordship, by that time, the caveat was filed and we were not aware that they have filed on that appeal, Lordship. Then, Lordship, the moment the appeal is filed, the authority, the learned court below, they are supposed to intimate us regarding the filing of the appeal, Lordship. So why the caveat is filed, Lordship? That Lordship is aware, Lordship. Now, subsequently, this title suit that was pending before the same court, we informed the court that there is a Kaba decision, Lordship, for which we have filed a caveat before the Honorable Court. So accordingly, they have filed this IA and the title suit was withdrawn accordingly, Lordship, which is at page 65.
Now, on which date?
Lordship,
So now you just give me the chronology. The caveat was filed 6/10/2025. Appeal was filed 13/10/2025. Title suit was filed when?
Lordship, title suit, that was, I'm instructed that was before the judgment and order of the Kaba decision, Lordship.
Before judgment and order.
Lordship, that title suit was filed. After the judgment and order of the Kaba, Lordship, this title suit was accordingly withdrawn, Lordship.
Okay, there was no wrong in withdrawing the title suit because they got to know that
Correct, Lordship.
system has come.
There is
Correct, there is no
nothing
problem
wrong in
with
this,
that.
Lordship.
Yes, now the CA was taken up when? When the order was passed?
CA was 5/2/2026, Lordship.
5/5?
5/2/2000, page 66, Lordship.
Page 66.
66. That too, Lordship, on reading of the order itself, Lordship will come to know that they have, in fact, on this day, they have filed one miscase for withdrawal of this appeal. But that was not done. And they have pressed for the main case and the stay order was taken, Lordship. Lordship, I am reading that into note, page 66, Lordship.
Yes.
Case record put up on the strength of misapplication, Lordship. Misapplication number 2 of 2020. This misapplication was filed for withdrawal of the civil appeal itself.
Where is that? You have
Lordship,
the copy
from-
of this application.
Lordship,
it comes from here, okay.
It's come from this order, Your
Yes.
Lordship. Filed by the appellant through his counsel, Tinima, for withdrawal
For withdrawal
of his petition number 464 of 2020. 464 is the civil appeal that is pending, Lordship.
46425 is the earlier one,
Lordship,
the title suit. Title suit, right?
correct. No, Lordship, this is the miss case, Lordship. 464 is the miss case, Lordship.
No. Case record put up on the strength of misapplication is 226.
Miss case is 46425, Lordship.
And what is 226 then? Case record put up on the strength of misapplication number so and so. So misapplication is 226 filed by the appellant through his counsel for withdrawal of his petition number 46425. The title suit is number, what is the number of title suit?
Title suit number is 5 of 25, Lordship. 5 of 2025, Lordship, page 65.
No, there was an earlier order in the IA 225 to withdraw the present suit, stating that he came to know from the written statement filed by the defendant that Kebang has already decided. So and so. So he wants to prefer an appeal against the Kebang decision. It appears that from the averment of plaintiff that he was not in the knowledge of the Kebang already passed the decision. There is a material to show that he made a representation to the Kebang to pass its decision, but the decision was not conveyed to him. So he filed that instant suit pending decision of the Kebang. As the Kebang has already passed the decision, so he wants to prefer a civil appeal against the Kebang decision instead of pursuing the present suit. Considering circumstances, his application for withdrawal is allowed for interest of justice. Accordingly, present suit is dismissed on withdrawal. So this suit of 5 of 2025 was withdrawn on 22/1/2026.
Correct.
Correct. Now,
Thereafter, the civil appeal which was pending, which was taken up.
5/2/2025. case put up on the strength of misapplication on file by counsel who withdrawal of his petition 464. 46425 is what?
No.
But he had filed this IA 2 of 2025. This is, see, there are two IAs, same number, 225 and 226. 226 is filed for different purpose.
Lordship, next paragraph, clear inference can be drawn, Lordship. Learned counsel,
See,
must
this
submit
case
that-
is, you are confusing. 22/1/2026 order, it was passed on the basis of IA number 2 of 2025. Correct? IA number 2025 for withdrawal of the suit,
Yes, title suit, Lordship.
title suit.
Correct, Lordship.
Then title suit number is 5 of 25.
Correct, Lordship.
Correct? So this order was passed. That was withdrawn on
Lordship.
22/1/2026. That has already been withdrawn, title suit.
Title suit already,
That work is over.
correct.
Now they have filed a misapplication of 2 of 2026 for withdrawal of his petition number 46425, which is 464. One
Lordship,
second, learned counsel submits that they file instant appeal against the interim court evaluation of so and so during the pending the title suit number 1 filed by him in respect to submit the pending disposal of the title suit. The appellant came to know that Kebang has made its intent decision, and to avoid delay in limitation period, he instantly filed a civil appeal for withdrawing the title suit. As both civil appeal and title suit were pending before this court in respect of the same subject matter, so out of confusion and due to bona fide mistake, the appellant filed a petition number in mind to withdraw the civil appeal pending before this court. But since the title suit is already withdrawn, so he wants to maintain the civil appeal and withdraw his petition number change. Yes, so what is wrong in this?
Lordship, in fact, he has filed 2 civil appeals, Lordship.
No,
Initially,
he has filed one civil appeal, one title suit.
Lordship, 2 civil appeal.
No,
Title suit
where you?
464 of 2025 is another civil appeal, Lordship, which was withdrawn on that day, Lordship.
As both civil appeal and title suit were pending before this court in respect of the same subject matter. So out of confusion due to bona fide mistake, the appellant filed a petition number Iman. This is a petition number this to withdraw the civil appeal.
Correct, Lordship.
So this petition is to withdraw.
Withdraw,
This
Lordship.
is the miscase.
Lordship.
Miscase was filed to withdraw the civil appeal. So where is the 2 appeals you are saying?
Lordship, that is mistake.
Civil appeal before this court, but since title suit is already withdrawn, it was stated that there was a bona fide mistake. He wanted to withdraw the title suit, but he filed 2 miscase to withdraw the civil appeal also.
Correct.
So that's why that title suit is already withdrawn on 21-1, the earlier order. Withdraw the civil appeal, but since the title suit is already withdrawn by him, he wants to maintain the civil appeal. So he wants to maintain the civil appeal and withdraw the petition 465. The 465 was withdrawn by him accordingly. So
Lordship,
civil appeal remained. Civil appeal then remained. So he said that he filed 2 misapplications. One misapplication, he already filed in the title suit. The another one also he filed in the civil appeal to withdraw it. That was done mistakenly. He said that since the title suit is now withdrawn, that's gone. He wants to keep this type civil appeal active. So therefore, he said that I have mistakenly filed 465-2025 to withdraw this civil appeal. Let me withdraw this
464.
46425. So 46425 was withdrawn.
Correct, Lordship.
So where is the illegality in this?
Lordship, when this particular main case was taken up, Lordship,
Hmm?
this withdrawal application,
Hmm.
along with that, this main case was listed, Lordship. Since it was not withdrawn, they have pressed upon the learned court below to pass the interim order without giving us opportunity of being heard. The caveat was still there, Lordship.
But caveat is already expired. It's 3 months.
But then,
time
Lordship,
has
we
passed.
have filed during the existence of that particular appeal, Lordship, which was filed on time, Lordship, which the time,
During the existence of which appeal? Title suit.
not title suit, Lordship, appeal, Lordship. Page 39, Lordship.
No, what is the rule of caveat? You will show me a judgment that after 3 months of the 3 months of filing of the caveat is still active.
Lordship, before the expiry of 3 months,
Hmm.
the appeal was filed, Lordship.
Correct, but appeal was not taken up. It was not registered.
It was registered,
How
Lordship.
do you know
Page
it's registered?
39,
How
Lordship.
do you know it's registered?
Page 39, Lordship.
Page 39 shows only that it was filed. But immediately the number cannot be given. No?
Lordship, it's there.
The
Lordship.
number must have been given later on.
This is a certified copy we have obtained, Lordship.
No, correct. I mean, once you file an appeal, civil appeal, immediately you'll be given the number. 452. File number 413102025.
Civil appeal 9 of 2025, Lordship.
So, I mean, so you show me the law that once the appeal is filed and registered, immediately you'll have to be notified
Lordship,
if the caveat is there.
for 148, Lordship.
Hmm?
Section 148A of CPC.
Yes, section 148, let's see. Yes, 148, let us see.
Very good. Lordship, under this section, step by step, the procedure has been.
Or you were not given a copy of this thing. In spite of the caveat, you have not been served with a copy of the civil appeal, or you have
Correct,
been
Lord.
served.
No, 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 I was not served.
Huh?
I was
You were not served.
No.
Or you haven't told the court about that. So you have not been served any copy of the
No, Lord.
application, or no, that appeal has been filed, no notice was given to you. Hmm. Okay, we'll stay that order. We'll issue notice and stay the order. Heard, Mr.
JG.
J. Jini, the learned counsel, appearing for the petitioner. Full stop. The instant. Instant petition filed under section 115 of Code of Civil Procedure 1908, challenging the procedural irregularity, challenging the order dated 5/2/2026 passed by the learned civil judge in bracket senior division, Deporizzo in BRJ stroke CA number 9/2025. The case of the petitioner is that the petitioner a member of the Tagin tribe, an absolute owner of ancestral land at Oju village, successfully defended his title before inter-village customary court of Nacho Circle, which passed a final decision in his favor on 23/9/2025. After the respondents willfully, how many respondents are there? After the respondents willfully defaulted on 4 successive summons.
13.
Four successive summons. After the aforesaid order dated 23/9/2025, the petitioner has filed a caveat in bracket F number 430 before the learned civil judge in bracket senior division Deporizzo on 6/10/2025, which was duly served so and so, notice of which was duly served to the respondents via registered post. Full stop. The respondents filed a civil appeal in bracket filing number 452 on 13/10/2025, when the aforesaid caveat filed by the petitioner was alive. Full stop. During this period, the respondents filed another title suit being number 5/2025 involving the same issue. However, the same was withdrawn on 22/1/2026 as they came to know, as they claim to have come to know about the decision of the Inter-Village Customary Court of Nassau Circle on 23/9/2025. Full stop. However, the respondents appeared and the respondents filed another miscase, being miscase number. What was the miscase number? Miscase number, respondents filed another petition number 46425, praying for withdrawal of the civil appeal before the Civil Judge Senior Division Depot Regio, which was taken up on 5/2/2026. However, rather than pressing the miscase, pressing the petition number 464/2025, it was contended that the petition was wrongly filed. Therefore, therefore the respondents did not wish to press the same. Rather, they would like to press the civil appeal. The learned trial court, by order dated 5/2/2026, allowed the petition number 46425 to withdraw. However, the learned trial civil judge senior division took up the civil appeal and without hearing the petitioner passed the impugn order, whereby pending disposal of the appeal, whereby it was directed that pending disposal of the appeal, both the parties shall maintain status quo and Kebang decision dated 23/9/2025 shall be stayed. Full stop. Being aggrieved by such order, by the impugn order, the petitioner has approached this court. And this court has seen that a caveat was duly filed by the petitioner on 6/10/2025, and it is also and the civil appeal number 09/2025 was filed by the respondents on 13/10/2025. Full stop. However, the petitioner claimed that no notice of filing the civil appeal was served on him in spite of his filing of the caveat, and the impugn order was passed without hearing them. Therefore, the interim order, the petitioner prays for stay of the aforesaid impugn order dated 5/2/2026. Full stop. After hearing the counsel appearing for the petitioner, this court is of the considered view that notice should be issued in the matter returnable within 4 weeks. By way of speed post, as well as under the usual process. Full stop. In the interim, the impugn order dated 5/2/26 is stayed until further notice.
Right.
Item number 3.
Decision
438 BNS bail application. The accused was arrested on 22/3/2025. Today is 358 days. Today is 358 days behind the bar lodge.
He's the NDPS person.
NDPS case. I am
You are his mother.
his father was expired lodge.
Huh?
This petition is mother.
Citizen is the mother.
Yes, lord.
And is NDPS and other illegal.
Other sections are that also.
So we'll issue notice at this stage. We'll call for the CD.
So lordship, they
PCR
can see the
lordship.
page number 24, the annex memo. They have no ground.
Okay, we'll see the CD. We'll have to see the CD.
Lordship, actually, the possession lordship,
Hmm?
it is, they recover in his, from his possession. That
Correct,
is
we'll
a-
call for the CD.
Yeah.
Yes.
Search CD is filed over.
Yes, lord.
Yes,
Such
lordship.
CCF already suspend on 21/1/2026.
Charge framed
Yes,
already.
lord.
Lordship, then TCR may be called for lordship.
This year,
Heard Mr.
G. Pukon.
G. Pukon, the learned counsel, appearing for the petitioner, appearing for the applicant, right? Yeah. Applicant also heard, only right applicant, not accused. Applicant, then you write, Mr. Al Hajj, the learned APP for the state, there is an application under so and so, so and so. Then you write the matter relates to recovery of
11
11.8 grams of heroin, as well as what are this arm?
Possession lordship, this also possession of the firearm lordship.
As well as a firearm with 6 live rounds. 6 live rounds and multiple spent cartridges from the position of the position of
accused
the
person.
accused person. From the position of the accused person, full stop. The charge sheet in the instant case has already been filed, and the matter is pending for evidence.
Evidence.
Pending for evidence, full stop. Let the registry call for the trial court record. in
Scan copy
connection-
lordship, scan copy of
Scan
transfer.
copy of TCR.
Scan copy of the PCR in connection with NDPS case number 47/2026, pending in the Court of Learned Special Judge NDPS, Arunachal Pradesh. Full stop. Let the matter be listed after.
That may be fixed, lordship. Because I am from Guwahati.
Let the matter be fixed on. When?
17 March.
Okay, let the matter be fixed on 17 March.
Public.
Or let us.
Item number 4.
Mati na.
May I please, Your Lordship? Also, this application filed by the complainant and the accused person jointly by invoking section 528 of the BNS law, Lordship, for quashing of the FIR, Lordship.
Hmm?
For quashing of the FIR and quashing of the FIR and the charge sheet which has been pending before the learned JMFC and Naharlagan, Lordship.
What happened?
What happened is that, Lordship, the accused complainant and the accused person, they are husband and wife, Lordship. And on the night of the incident, Lordship, when the husband, he decided to marry the second wife, Lordship. And because of that, the relationship between the complainant and the accused person was, acrimony has been started between them, Lordship.
Mhm.
And accordingly, on the 6/7/2024, Lordship, the petitioner number 2, who is the complainant, Lordship, has lodged in complaint with
Listener number 2 is the wife.
wife, Lordship, who is the complainant, Lordship.
Hmm.
First lodge an FIR before the police station, Naharlagan, or woman base, Lordship.
Yeah, look, Dewey is wife,
A wife, Lordship.
and he's the husband. And both of you are staying together now.
Now they are, yes, Lordship, they are husband and wife, but they are living separately, Lordship. Because the petitioner number 1, he already married a second wife, Lordship. And to that effect, Lordship, the
No, I
agreement,
mean, you tell me one thing. I mean, by signing a agreement before the notary, whether a divorce can be resolved. I mean, a marriage can be dissolved.
No, Lordship.
Then why you have made this?
This
The
is,
mutual divorce agreement.
this mutual divorce agreement, Lordship, has been executed by the parties, Lordship, without.
Correct. I mean, whether on the basis of this, I mean, you can dissolve a marriage. And if the court passes any order on the basis of this agreement,
Yes, Lord.
then it would be like court is giving sanctity to this.
Yes, Lord. But on the basis of this, Lordship.
No, I'm asking this on the basis of this, whether I can pass I have gone through this.
Yes, sir.
I've seen this agreement.
Lordship.
Now, on the basis of this deed of mutual divorce agreement
Lordship.
and certain conditions you have written that we have agreed this and this,
Yeah.
and you want to settle this.
Lordship.
Now, if I take this into account, then it will be like the court is giving sanctity to this. It should not have been a deed of mutual divorce agreement and any other kind of divorce agreement whereby you have settled your mutual disputes, then it would have been different thing.
Yes, Lord.
But here now you have given a deed of mutual divorce agreement. And herein you have given certain conditions, terms and conditions saying that like we have mutually agreed, we have agreed upon this thing, we don't want to pursue the case, all these things you have written here.
Yes, Lordship.
And then some money has been also supposedly paid.
Yes.
One-time alimony. Whether it can be done like that. I mean, I'm just asking you, in your customary law also it can be done.
And usually, Lordship, they are practicing like that in the village area also. Because earlier, before the coming into the.
But for the village area, maybe some customary court is there on the basis of some court's order, but whether this can be done, deed of mutual divorce agreement only by signing before a notary public.
In fact,
And
Lordship,
on the basis of this agreement, if the court passes some order, then it would be like giving sanctity to this. You understand?
yes, Lordship, that is correct, Lordship,
But if it would have been a different agreement, then it would have been something else. But if you have here written here divorce agreement, there's some permanent alimony you have paid. I mean, the marriage cannot be dissolved like that. Nowhere.
yes, Lordship. But to my humble understanding, Lordship, since the party have already mutually decided to leave peacefully, Lordship. But
So where is that agreement now?
not, for that, Lordship, there is if required, Lordship will file an additional affidavit to
You
bring.
file
on
an
record,
additional affidavit.
Lordship.
You file an additional affidavit saying, I mean, because on the basis of this agreement,
Yes.
divorce agreement, it cannot be compromised.
Lordship, in the meantime, Lordship, notice may be issued and.
No, why
proceeding-
notice is, I mean, you filed that because you filed it. No, notice, why notice is required? You want to settle the matter, right? Compromise.
Lordship.
What's that? You are saying that like you both of you are mutually agreed and this and that. You
Yeah.
come up with an agreement, then the court will see. Notice to whom?
Not
The
a,
other side.
not a Lordship, for the records, Lordship. For the
Hmm?
records.
Because you have filed jointly.
Yes, Lord.
Then to whom to send an notice?
For the LCI, Lordship, from the law court also, where the matter is pending.
I don't know what you're submitting. I mean, the court is willing to compromise your case,
Yes.
dispose of your case. Why do you want the TCR or lower court record? What will be there?
Lordship. Then I'll bring on record with the additional, I'll bring on record the agreement which has been agreed by the party.
You bring on record that agreement. You bring on record. You bring a separate agreement whereby both of you have mutually agreed your disputes.
Yeah.
But don't bring in this divorce thing and all.
Lordship.
If you bring this divorce thing and like that you have divorced each other by way of an agreement which has been signed before a notary public, then the court cannot take into account
Lordship.
that document.
Lordship.
Because that will mean that like court has given sanctity to that.
Lordship.
Cannot be done.
That's correct.
So you will file an additional affidavit, heard Mr. So-and-so, the counsel appearing for the petitioner, also heard and handed an APP for the state. They have a learned counsel, prays for some time to bring on record a relevant document, relevant document connecting to the instant case, post of prayer is allowed, let the matter be listed when,
After a week, Lordship.
not after a week, next
Lordship.
week we file.
Next-
Why do you need so much of time?
Because that case, Lordship, this matter is
12,
Lordship.
correct? You file sufficient time, so that
Yes,
only you need to be parties have I mean, you have filed it jointly.
Lordship.
So you just need to get an agreement on that is,
Lordship.
something has to be there on record.
Lordship.
But on the basis of this, I mean, this order cannot be passed.
Correct, Lordship.
Yes.
Matter number 5. Mayor Lordship.
Mm.
Lordship, this is a quashing petition filed under section 528 of BNSS. Quashing of FIR bearing number 90 of 25, registered under section 316 clause 2, 318 clause 2, and 319 clause 2 of BNS, 8 New Delhi Police Station. The charge sheet is not filed yet, Your Honor, in this matter. So, as per the allegation in the FIR, Your Honor, may kindly see the page number 18. So 18 is the written FIR, Your Honor. As per the FIR, there is mainly two allegations. The first allegation is that on 21/1/2025 and 24/1/2025, respondent number 2 has disposed an amount of rupees 3,10,000 and 15,96,562 rupees to K Square Motor Private Limited for the purchase of the Tata Harrier, which was later taken out by the petitioner by stating that the respondent number 2 has given the authority, and when the confronted, the petitioner stated that she will assure to return back that vehicle or pay back the some money. But later on, she did not pay back the amount, and instead of that, she approached for the purchase of the land, which is located in Julang, Your Honor. So for that, as per the allegation that the respondent number 2 has paid an amount of rupees 49 lakhs to the broker Srimati Yalu Kabak and 22 to the petitioner, Your Honor. And later on, after that, sometime the respondent number 2 came to know that the agreement was executed between the elder brother of the petitioner and the landowner. However, actually, the fact is that, Your Honor, the respondent number 2 and the petitioner, they were in a relationship. The actual fact is, and during their substantial of the relationship, mostly they used to reside outside the state of Arunachal Pradesh, sometimes Shillong, Delhi. For that, the petitioner did not know about the marital status of the respondent number 2. So when she came to know that the respondent number 2 is a married person and with also had a children, she cut off the relation, terminate the relation by confronting the respondent number 2. The terminations, the respondent act in an aggressive, and on 21/8/2025, he unlawfully entered the rental apartment of the petitioner and physically assault her and also damage her car by planting the stone, and also forcefully snatched the cell phone of the petitioner, which contained a crucial evidence about their marital relationship, Your Honor. After those incident and all this incident and termination of relation, this impugned FIR is launched, Your Honor. And regarding this transactions amount, Your Honor, actually the petitioner earlier have one Tata Nexo car which got accident. So the person who caused the accident, that person has compensated an amount of rupees 15 lakh. I have annexed the agreement, Your Honor. May kindly see the page number 31. This is agreement between the person who caused the accident and the petitioner. In 32, page number 32, Your Honor, in paragraph number 2, whereas due to the pretty misunderstanding between the party, a conflict was arise on 11th day of January 2025 near CRPF camp Sinki View, Itanagar. As a result, one Tata Nexo car bearing register number so was damaged. And in page number 33, it is a money acknowledgement received, Your Honor. The 15 lakh rupees was compensated as a damage for the car, Your Honor. So this amount has been given to the respondent number 2, since they at the time they were in a relationship, Your Honor, for the purchase of the new vehicle. And Your Honor may see the next page, page number 34, Your Honor. This is a check, Your Honor. This check was issued
Now
by.
what happened? You have mutually agreed.
No, Your Honor.
What has happened? Now, what is this agreement, page 32A?
This agreement, Your Honor, this agreement is between the person who caused the accident, Your Honor.
Between the petitioner and?
Petitioner and the third party, Tata Tong, who caused the accident. So earlier, petitioner have one car which got damaged by this person, Your Honor. So this agreement is between the third party and the petitioner. So in this, Your Honor, 15 lakh was issued to 15 lakh was paid to the petitioner as a compensation. So this 15 lakh was handed over to the respondent number 2, since at that time they were in a relationship. So page number 34 is a check, Your Honor. This check was issued by the respondent number 2.
But it is in ND Enterprise.
Yes, this ND Enterprise is a respondent enterprise, Your Honor. Respondent number 2 enterprise, Your Honor.
So respondent number 2 has given to the petitioner.
Yeah, no, this was given to the dealer for the purchase of the vehicles, which was alleged in the FIR, Your Honor. Earlier, this check was issued. However, the dealer refused to accept this check
No, I'm
and
not understanding what you're saying.
Lordship, first of all, Lordship, all the sections are compoundable in nature, Lordship.
Hmm?
All the sections are compoundable in nature.
No, correct, but
Yeah.
now, I mean, they have come for what?
Quashing
What is
Lordship.
the-
quashing, yes, Your Honor. Your Honor, the respondent has alleged that he has transferred certain amount for the purchase of the Tata Nexo, and that car was took by the petitioner, Your Honor, by stating that he has authorized. Whereas the actual fact is the amount which was earlier compensated, that amount was given to the respondent, and that respondent has paid that amount to the dealer. And now the transaction which he has done is now he projected as a cheating in the FIR, Your Honor. And also, Your Honor,
One second, one second. Charge sheet is not filed.
yes, Your Honor.
Charge sheet is filed in the case?
No,
Yeah,
sir,
Not yet.
not yet, Lordship. And Lordship, all the sections are compoundable in nature, Lordship. So that Lordship, they are coming here for the quashing, Lordship.
No, they are coming here means who has come? Only petitioner is coming,
Yes, Lordship.
not the other people.
The
Other people are not there.
yes, Lordship. Lordship, here,
I
Lordship.
mean, whether this thing can be compounded without other proper person's presence.
No, Lordship. A notice to be served, Lordship.
Huh?
Notice to be served to the to the respondent.
Notice has to go.
Yes, Lord.
There are serious allegations. Which are the sections they have put in? 316(2). 316(2) is compoundable.
Yes,
Yes,
Lordship.
all
All the
sections
sections
are
are compoundable, Lordship.
316, 18. BLS.
Lordship, whoever commits criminal breach of trust shall be punished with imprisonment of either description for term which may extend to 5 years. It may be compoundable by the owner of the property.
Where is that? Where is that?
Lordship,
316.
316, Lordship. Clause 2.
Which may extend to 5 years
Yes,
or
sir.
fine and both.
Compoundable, Lordship.
Compoundable under which section? 20? 20? What was the section? Anyway, at this stage, notice should be. We'll consider this hard unless
Are conflicts.
so and so the learned counsel appearing for the petition. And so I'll have the learned APP for the state. This is an application under so and so, right?
Lordship, scan copy of case study may be called for.
Okay, call for the scale, because call for the case diary. Let the notice be issued to respondent number 2. Notice to respondent number 1 is dispensed with. Call for the scan copy or the copy of the CD.
Scan copy of the case study, Lordship.
Okay, scan copy of the case diary. And call for. And let the matter be fixed on when it can be done. 18th.
Yes, Lordship, because a notice has also should be go, Lordship. Then,
So 18th, Lordship. Let the matter be fixed on 18th.
like a 31.
Notice by speed post, huh? Notice by speed post.
Item number 6,
And steps within 3 days. Steps within 3 days.
Yes, madam. Madam, by the application on paying for quashing of the FIR, registered under section 339(2) of the BNS, which is a criminal trespass. Madam, from the record, I'll show that this FIR has been filed in retaliation of the FIR which I have filed, only with the sole object to neutralize the official duty.
You were the DFO.
My lord,
So you went to some place for, there was some, there was some incident of bamboo cutting or something.
my lord,
So you went there, then there was a case filed against you for trespassing.
my lord.
We'll issue notice at this time.
Till then, my lord, investigation, my lord, since my duty is, my obligation is bound by law and justified by law. I cannot be booked under 389(2). It's a simple law,
Which is to be stayed, which is to be stayed.
the FIR. Because in the name of the FIR, my lord, I have been harassed by the officers.
Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. P. the learned APP for the state, region application under so-and-so. Then you write an FIR was lost. When was the FIR filed?
The FIR was filed on,
Filed on 12/2/2026.
which was registered on 25 without.
which was registered on
25/2/2000.
25/2/2026. Before,
Sejusa Police Station.
before
Sejusa Police Station.
Sijusa Police Station, Arunachal Pradesh. Sijusa Police Station, which is the place, Sijusa.
Sejusa, Publication District.
To the alleged entirely that where is that FIR?
FIR, my lord, will find at page number
35.
35.
Lost by so and so, lost by one, Srimati Yari Nabam, alleged entirely that she is the owner. She is a lady, right?
Lady.
She is the owner of a plot of land in A1 village situated in front of ADC office, Seoji. That on February 11, 2026, at about 10:30 a.m., during her absence, the accused applicant, along with one mopping agent, in bracket RFO, Seojosa range, accompanied by armed personnel, arrived at the site in a forest vehicle and forest truck. That without providing any prior notice or search warrant or any legal authorization, the accused applicant, along with the opposite persons, entered into her private property and dismantled the standing structure using heavy machinery and tools. Full stop. On the basis of the aforesaid FIR, the police registered the case. Police registered Seogia Police Station case number 202/2026 on 25/2026. The learned counsel, I think the accused applicant submits that the accused applicant is a divisional forest officer, and she, along with the range officer, concerned range officer and other forest officials, went to the place concerned on official duty after receipt of an information that illegal bamboo cutting was being done at the place. He submits that she went on her official duty and there was no trespassing or destruction of any assets of the informant as alleged in the FIR. Also, let the notice be issued on respondent number.
There's no other respondent.
We have not made
Right.
respondent. Let notice be issued. In the meantime, the FIR. In the interim, the FIR getting, which was her FIR, same FIR.
FIR, Sejusa.
You have also filed a FIR.
Yes, madam. Sejusa Police Station case number 2 of 2026.
This is maybe state until further on this.
Good.
Let the matter be fixed on. And we'll have to call for the case diary, write the case diary, scan copy of the case diary and fix on 19th March.
Good. Madam, the other one is the RF format. Similar order with a
A similar order in the,
different name.
he is the range officer.
Right.
And the lady has also come, it seems.
No, item number 6 is the DFO and item number 7 is the RFO.
RFO, the same order. Yeah, range officer.
Good.
Item number 8.
Yes.
So this deck is filed by the petitioner for passing of their affair number 99 to 18 of Itanagar Women Police Station. Lordship, this is a petitioner, no more husband and wife. Lordship, the affair is Annexure 1, this page number 12 to 16 is the affair.
Where is the agreement?
Yes, Your Honor, Lordship, agreement is the Annexure number 4, that is page number 40 to 41.
Page number?
40 to 41, Lordship. Here, the board party has settled, and this agreement is made on this by the board party in presence of these family members. Also, this case is has been charged and it is for trial before this JMHC Halagan. And Lordship, after filing this affair, the board party are staying. After a few months, they are staying in the same room. And
The husband and wife.
yes, yes. Lord. So let's my pair interim maybe.
Mr. Zini, I mean, I don't think a courts are required in this.
Yes, Your Lordship.
It can be disposed of against
Yes,
this.
sir.
Yes,
I mean, these are husband and wife, not heinous crime, simple injury and
Yes, Lord.
mutual this thing.
yes, Lord.
So we'll dispose it of.
Yes,
We'll
Lord.
dispose it of.
It-
Well, I'll pass the order.
Yes.
Dispose it of.
Deliverers.
Item number 9.
Map area.
Yes.
Madam, this matter related to land acquisition matter, madam. Madam, notification was issued for the land acquisition of food track from Lamnio to Longchu. Madam, maybe please to see in page 80,
Please.
page 80. Zero is the notification that annexure 3.
Yes.
Yes, pair that one. Dated 24 January 2022. And notification was issued under Balipara Tirap Sadia Frontier Track, Jum Land Regulation 1947. May I just read the second paragraph?
Okay, this notice was issued for land acquisition, then what happened?
Yes. After that, my lord,
And land was acquired for what?
land was acquired for the,
NHI DCL project.
yes, the executive agency is the NHDCL. Land is for coal. In second paragraph, may I read that second paragraph notification? Described below, it appears to the governor of Arunachal Pradesh that the land in locally are described below is required to be taken by the government for the public purpose, namely purpose of construction of food track measuring 53.51 kilometer wide, 5.40 meters, 18 foot under East Kamen district of Arunachal Pradesh by National Highway and Infrastructure Development Corporation.
This is
Limited.
not food track.
Yes, this is a food track. It's around 5.40 meters. That
5.40 meters
that
width.
weight, yes.
Mm.
And then total square meter is 0.28. May your lordship may see in the table. Lamnio to Longchu is 0.28 square kilometers.
Lamnio to Longchu and 0.28. Okay.
Yes.
The notification was issued, then what happened?
Then my lord, this was date is my lord, date is 20.
Who are you? Who are you? Who is this person? On the screen? Why are you, is it your case?
Yes, sir.
Is it your case? Is it your case?
Next time I case.
Then
Lordship.
why are you
Sorry,
shouting? Then why are you shouting?
sorry, Lordship.
Keep your mic in mute mode.
Yes, my lord. My lord, after this notification, my lord, it was published in the Arunachal time, my lord. So date is publication, date is different, my lord. Publication date is, my lord, you may see 22
Now,
March.
this came on 24 January notification.
Yes,
Then
but then it was published on 22 March 2022. It's a page 81.
Page 81.
page 81. And then the notification is page 82.
The page 81, I can't see where is the notification.
No, it's 82. 82.
82, yes,
Middle table.
yes,
last
the bottom one.
Yes, bottom one.
Okay, it has come on
22 March 2022.
22 March 2000.
Yes, as per the notification, if there is an interested person, then they have to file claims and objections. So now the petitioners, they have filed claims and objections. Claims and objection will be page 84. Page 84 to
No,
100.
okay, you just short your
Yeah, short, my lord.
shorten your case.
Yes.
So now what has happened? Notification was issued, then I mean objections were invited. Then you have put in your objections, or you agreed to that. What?
Yes, and then what happened was that Deputy Commissioner has not done any site verification and spot verification. They just have a meeting with the society and decided to disburse the compensation to the 21 person, my lord, to the societies.
There was a discussion with the society.
Yes, so that's I will just come to that page.
And society, I mean, society is consist of how many people?
Basically, they are not land owners, but then they have decided to disburse among the societies. That's what we have challenged in earlier writ petition. But then subsequent what happened?
As per the Land Acquisition Act,
Yes.
notification was issued, then objections were invited. The DC was the authorized officer as per the Land Acquisition Act. Then he convened a meeting.
With the society who are not land owners.
Which is the society?
I will just come to that page 130 to 133. There is a minor submitting
132.
130 to 133. I will just read the 130 first paragraph and then second paragraph. 130 Miller. I will just read the serial number 1. The land compensation in respect of such and such river to Longchu shall be distributed in
Which
term-
serial number 1?
the one
No, page 131.
page 131.
No, what is the context of the meeting?
Meeting basically it was just only
With whom? Who were there?
they are not basically land owners, my lord. They just have a meeting with a deputy commissioner and decided
No,
to
let us read, no, what is
Yes.
there? In person to the meeting notice so and so. A meeting was held on 21st. One meeting already happened in Baming on
Yes.
13 July in connection with so and so.
yes, my lord.
A meeting was held today on 21st July under chairmans of so and so ADC. The meeting was attended by so and so, on this side, and all representatives from the affected land areas took part in the meeting.
So now in this meeting, they decided to distribute compensation among to the
No, wait, let me understand. I
yes,
mean,
my lord.
all representatives from the affected land areas took part in the meeting.
That is
Hmm?
no, they have not participated by that.
The attendance of all participants were taken
It
in
is-
separate
it-
seat, and same is tagged with the file.
Yes, my lord.
Laminio villages have been represented by General Secretary, Laminio Welfare Society, and other members of the society. Jokio villages have been represented by Chairman of Jokio Society and other members of JWS. 4 speakers, each from Jokio and Laminio, were allowed to speak in the meeting, and
Yes.
1 speaker, each from Langchu and Jomo villages, had spoken in the meeting. The existence of the agreement dated 18th December 2022 is not disputed. What is this agreement?
This is, I think, agreement is among the
Is not, no, this,
private people. As per the petitioners, they are the land owners, but then there was having a meeting of private peoples, and they have a meeting and agreement, and then they come to a deputy commissioner, and then this was the last conclusion meeting. This was the last conclusion meeting, my lord.
that is so and so is not disputed. So there, this agreement will be relevant. it is stated that the agreement inter alia that a plot of land situated in between Wazing River,
Yes.
Waging River and Longchu is disputed land area. And parties so and so have agreed to distribute the land in compensation in 4 heads,
Yes.
such as Laminio community, Jokyo
Jokyo,
community,
Puru community,
and core
core committee.
committee at ratio of so and so, so and so.
such and such.
So that was the agreement whereby they agreed
Yes,
agreed
yes.
to this.
Yes.
For it is also stated that in the said agreement that Jokyo Welfare Society, Jokyo villages have no issue or an objection on the land situated between Takerang and Wazing River. After long period discussion, the members the other in the government representatives, President so and so, unanimously agreed upon the land compensation in respect of so and so, this is in terms of agreement, so and so, so and so. The beneficiary list of the land compensation shall be prepared 4 heads. Lanchio community, Jokyo community, Pupiroli community and core committee. The
Yes.
estimate of land compensation amount should be done on so and so, so and so. After ownership is proved through local settlement or along with these parties, even in case of either of the parties, Jokyo and so and so lost got defeated in the clear the land compensation will be distributed. What is so this is fine, yes.
Yes,
And-
after this ballot,
Hmm.
they wanted to distribute the compensation
Hmm.
amount, then during the pendency of a repetition,
Hmm.
so we file IA. IA is in 139
You
saying,
filed a writ petition for what?
repetition was saying that
A
repetition.
separate writ petition
Yes.
you filed, and in that writ petition, and they wanted to distribute the money, so you file an IA.
Like in the first, there's one writ petition first we have filed is that they have not issued notice to the landowners. They have issued notice to the private people who are not landowners. That is one prayer. Another prayer was that the land, they have to do the spot visit, the field visit and identify the land and pay the compensation. That was the prayer in the earlier writ petition. So during the pendency of writ petition, what happened, this meeting all has come up. Then we file IA saying that this has to be stayed. So now at page 134 is the IA we file for the stay. The relevant portion is then page. May I just read?
So DC was asked to do the inquiry, right?
My lord, they-
Accordingly, provided the Aneka Commission distributed decision of the meeting. So and so.
then we
Yes.
file IA and then that committee was stayed, saying that, I'll just read 170,
Correct.
70,
178.
79, paragraph, serial number 8.
Mm,
May I just read?
mm.
Accordingly, it is provided no land acquisition company shall be distributed to anybody pursuant to the decision taken in a meeting held between the aforesaid communities dated 21/7/2023 under the chairmanship of such. This was the meeting was held by the additional deputy commissioner.
That was the meeting at page,
The meeting which
that had to be read
which you have already read, my lord.
correct.
Yes.
And
So
that is
now-
also Burang.
So now
Then it was directed to what? Directed what?
directed to not to disburse.
Huh?
Directed to not to disburse.
Ladet, the government advocate shall intimate the deputy commissioner. Only state.
Yes, my lord. So-
I mean, compensation was not to be distributed as per that meeting,
That's what I meant.
correct?
No, what happened was that this information we came to know little bit late, and then
Oh.
we challenged the minors of meeting. But then what happened that before this challenging compensation, we got the document saying the compensation was already distributed to the private parties before the operation of this stay. So it is in page 180. It was distributed to the 21 person on the basis of the meeting dated 21/7/2023. May I just read 180 page from the order?
Yes, it was done in 31st October and order
Yes.
came on 10/11.
Yes,
So these people got some money.
yes, it was distributed to,
They are from those villages. Siang, Laminio, Raju Lamino and Jokyo. I mean, that was decided, the Jokyo Lamino villages will
yes,
will be given.
I will just read the relevant paragraph.
Hmm.
I will just point out the relevant.
Hmm.
This is to inform that the following persons for
Mhm.
the Lamino Longchu food track compensation amount, that the amount which will be distributed to them against their names shall not claims the land as their own in near future as the lemno longitude compensation amount is being distributed based on the mutual agreement 21 July 2000
That agreement-
same agreement which you have
Yes.
agreement held as a whole the lemno nampe such and such, all of them agreed that distribution of compensation amount is based on the mutual understanding, and all the above mentioned claim a client to receive the compensation amount among them and not to disturb any development project in their area. And since the actual demarcation of important ballot, actual demarcation of land could not be ascertained. And due to absence of any documents proof of the land ownership by any individuals, groups, hence they shall not claim the owner of the said broad stretch of the land in future based on the compensation amount they receive at the lemno longitude tract compensation. Now, after this, my lord, what happened? The petitioners, they filed complaint saying that they are not land owners. After the filing complaint, deputy commissioner has lastly, they have to do the spot verification and identify the land, my lord. So that I will come to that reports. So as per the reports, saying that petitioners are the landowners and then they have paid compensation. All the petitioners, they have been paid compensation, but then they say that we are paying only 30% now. The rest amount paid to the private this 21%. They have not said anything. Only mentioned that it is a due. I will come to that document, my lord.
Now, after that spot verification, verification
Yes,
by the DC,
yes.
DC decided to pay the land, land values to those owners.
No, landowners, yes. Who are the petitioners here, my lord?
Who are the petitioners?
Petitioners, yes.
Correct. That decision was taken.
Yes.
Then some amount was paid.
Some amount was
Amount
paid.
was already paid.
Yes, my lord.
Now, what is the problem?
So my problem is that as per the Section 10 Jailer Act, even if it is used for the acquisition of land acquisition, but then compensation has to be paid as per the LARA Act 2013. Computation has to be done as per LARA Act. But then as per their compensation assessment, there is no land market value, no solatium, no value attached to the land, no multiplication factor. As per the LARA Act, there are two schedules. One schedule has a compensation components. It includes all these components. Another is the rehabilitation, but we are not talking about, we are not seeking
So
rehabilitation.
you are basically saying that like your land, but you have already taken the money.
Yes, money, but then the award is not legally, award is not passed.
No,
They have just only.
Once you have, then on what basis you have taken the money?
My lord, we have taken on protest, my lord, saying that, and we also file a complaint against because money which is paid to the 21% illegally.
Yeah, 21%, let's just keep it
Yes,
aside
sir.
now. 21% illegally paid. But after spot verification, some money, the people who owns the
Yes.
land, people who own the land, and they have been identified,
Yes, my lord,
and petitioners are also amongst them,
among them.
and some money was paid.
Yes, my lord.
And money was paid on what basis? You are saying now that there was no calculation, there was no market value.
I'll just show to. I will
Correct.
come
No,
to
just
that.
let me just understand this.
Yes.
Then some amount was paid to you, and on what basis you have taken that amount then?
My lord, because there were series of complaints and all the villagers, my lord. So they thought they got some money, then why don't we take the money? That's how they have taken. But then they said that.
Okay, now
money-
you are saying that, that money was not, that money, whatever money was paid, it is not sufficient because there was no, there was not basis of any kind of, this thing, law which has been made.
Yes, yes. As per the
Not as for a land acquisition.
land acquisition.
Not, that somehow they have decided the amount and like they have paid.
Yes, exactly.
On what is the basis that you were not aware of this?
Yes.
So on that basis, you have filed this application.
Yes, my lord. I'll just take to the report, my lord. Maybe please to see the report.
No, I think like at this stage, we have understood the matter. I know,
Yes,
at this stage, nothing can be done other than
Yes.
issuing notice.
Yes,
So we'll issue the notice. Let them come back.
Yes, yes,
come
my
back.
lord.
Heard, Mr.
Esmo.
I didn't get your name.
Esmo.
Esmo.
Yes, my lord.
Esmo, the learned counsel appearing for the petitioners, also heard MS. So
One moment.
yes, additional
No, man, government advocate, man.
Yes,
T1.
government advocate. You are appearing for all the.
Yes, man. Only 4 respondent, man.
Respondents for the government side, then you write the instant application under Article 226 of Constitution of India has been filed by the petitioners. Filed by the petitioner with the following prayer. You write this prayer, so from 1 to 4, and from the prayer part at page 35. Full stop. Then you write the case of the petitioners is that the lands of the petitioners are situated at various villages under East Kameng district was acquired for construction of food track from Lemnio to Langcho. In bracket, you write from kilometer 0.00 to kilometer 60.514, bracket complete. Circulars for survey, stroke verification, assessment of property were issued and cancelled time and again. And ultimately, bills were prepared without any site visits, and almost 70% of the land compensation was paid to. This 21% are that those 21% you're saying?
Yes, they're not landowners.
Paid to 21 persons who were not the landowners and not affected by the project in question without any basis. It is the case of the petitioners that after the petitioners approached the DC, SEPA, only SEPA survey and field visit was done, and only 30% of the compensation was paid to the petitioners. However, the compensation was not based on any market rate of land, solatium, interest, multiplication factor as mandated under the land acquisition. What is this like LLARR?
The right to fair compensation transparency.
No. LARR.
That's a short form of right to fair compensation.
Hmm?
This is Lara.
What is the full this thing? Yes. Right. Under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, amended on 2023.
Yes.
It was amended or not? What?
Yes.
Hmm?
It was, yes, amended, my lord.
2023, it was amended.
2013, sorry.
You have wrongly written 2000, this thing.
13, my lord. Just,
Act
to the 13, sorry.
2013.
Yes.
2013. Full stop. Therefore, the petitioners contended that they have been denied with their rightful land value and compensation accordingly. Full stop. Being aggrieved, the petitioners have filed the instant writ petition before this instant writ petition. Full stop. Let notice be issued on let notice be issued, returnable in 4 weeks. Is there any other respondents? No,
Only
the-
government response.
Chairman.
returnable 4 weeks. Notice to respondent, notice to the respondents are dispensed with, and the learned government advocate has appeared for all the respondents. However, requisite numbers of extra copies to be served on the government advocate within 3 days from today. These 3 days from today, let the matter be fixed on when. No, let the matter be fixed after 3 weeks, after 4 weeks, after 4 weeks.
Applied.
Item number 10.
May I please, Lordship? May I please, Lordship?
Yes.
Lordship, the petitioner married one, namely Shantanu Dhara, alias Arif Ahmed, Lordship, in the year 2015, Lordship, as per Muslim rights and rituals, Lordship. With their wedlock, Lordship, a female child was born in the year 2016, namely Rifat Andum Ahmed, Lordship. Lordship, Shantanu Dhara, the husband, Lordship, was working as a pharmacist at Kanobari CSC, Lordship, and he lived in the government quarter at Kanobari CSC along with the petitioner, that is the wife, since their marriage, Lordship. Later on, Lordship, it was informed that, Lordship, Shantanu Dhara married earlier one lady, namely, Lordship, Sawarnil Dhara, Lordship, of Purno Medinipur, Lordship, West Bengal, Lordship. They separated each other in the year 2003, Lordship. Lordship, she lived in Kolkata and never come to the matrimonial house. That's why he married in the second time, Lordship, in the year 2015 under Muslim rights, Lordship. Lordship, the earlier wife filed a maintenance case. In the maintenance case, he stated, Lordship, it is in page number 16, Lordship.
So what is your prayer? What is your prayer?
Okay, Lordship, he stated in this petition, Lordship, I have married.
Petitioner.
Sorry,
Yes.
Lordship, the
Yes,
husband of the petitioner said before the daughter, I have married this lady. That means this is the petitioner. For the second time, I shall not keep any connection with you any longer. You cannot give company as a wife, so I shall divorce
No.
you.
What is your grievance? What is your prayer?
Lordship, I am going to that point, Lordship, and
Come to
similarly
that
in
point.
the
No,
end.
come to the point. Come
Okay,
to that
Lordship.
point.
Lordship,
What is your grievance and what is your prayer? Petitioner is who?
Lord,
Who is the
Lordship,
petitioner?
suddenly my husband, Lordship, Shantanu Dhara, died on dated 18/6/2025, Lordship, at Health City Hospital, Guwahati, Lordship, and I received the dead body, and I have completed his funeral works, Lordship. But Lordship,
You are the first
application
wife. You are the first
second wife,
wife.
Lordship. I am
You
the
are the
second wife.
The first wife is
Lordship.
already divorced.
Divorce petition has been filed but not completed. Before completing disposal the divorce
Before
petition,
completion,
he died, Lordship.
Before completion of the
Lordship.
divorce petition, he died, but he married you.
Yes, Lordship.
But before the divorce petition was settled, he married you, right?
Yes, Lordship.
Huh.
Yes, but under the Muslim rituals, Lordship. But Muslim law, biogamy is permitted. That's why he.
As per the pension rules, whether it is permitted like that.
Lordship, I have a daughter also, Lordship.
Daughter from whom?
From Shantanu Dhara, from second wife, Lordship. I am second wife.
That you have a daughter also.
Yes, Lordship.
Now what has happened? What is your grievance?
Lordship, application made to the Director Health Service Arunachal Pradesh, Lordship. The application I have annexed in page number 41, Lordship, represented, but they have not taken any step, Lordship. Thereafter, we have
Application was
Lordship.
filed by the first wife. Application
Second
was
wife,
filed by
Lordship.
second wife.
Second
Yes,
wife,
then what
Lordship.
happened? Yes, then what happened?
They have not taken any step, Lordship. Thereafter,
Correct.
thereafter I went to the to my quarter to receive my household items, electrical items, the AC, fan, etc., Lordship.
Okay.
But the
okay,
respondent
then-
authority, Lordship,
yes,
Lordship,
then
but the respondent authority informed me that the household items received by Saurni Dhara, the first wife, on dated 11/10/2025, Lordship. And in this regard, I have lodged an FIR in the Kanubari police station, Lordship, but they have not taken step, Lordship. And the DMO, Lordship, the district medical officer, it is informed me that the first wife already applied for pensionary benefits and gratuity benefits, and the process is going on, and they will not stay the procedure according to our application because it is not mentioned in the service book, Lordship. This is the fact. And as I am the wife, and I have a daughter, I have right to claim the pensionary benefits and gratuity benefits, Lordship. The birth certificate,
so what is your prayer?
my prayer, Lordship, along with the first wife, Lordship, and
No, no, in a repetition, what you are seeking for giving a direction to Kanibari CHS to return the furniture to you.
yes, Lordship, it is actually, Lordship, it is a criminal. Interim order we want, Lordship, so that
I mean, we will this read court will direct. I mean that return those. I mean those household goods already taken by the first wife. We will direct that to be given to you. This is your prayer.
That is one prayer, Lordship, and main prayer is that we have to take the benefits of the pensionary, Lordship, of my husband, Lordship, and for my daughter. And interim order.
We'll issue notice at this stage.
My lord, one thing was just
Lordship,
to point
interim
out.
order maybe first because,
No
Lordship,
interim order.
the petition is going on process, Lordship. If before disposal of this petition, if the process is completed, they will get the benefit, all the benefit, and I will be left, Lordship.
My lord, one point, my lord. Here, as per the version of the petitioner, the deceased person was serving as a premises before in the CHG Kanubari, which falls under the DMO Longding, my lord. Now, in case of such cases, my lord, all the pensionary benefit official process has to be initiated from the concerned DMO. But here in this case, the DMO has not been made as a party. One account, my lord. The second part, my lord, all the clearance has to be finally done by the Director Audit and Pension, and the Director Audit and Pension is not a party here, my lord. Now, this important, the respondent, the necessary this respondent has not been made as a party. This is required to be made as a party. Unless they are made as a party, my lord, we cannot have a complete instruction on this matter. And
Lordship,
other account, my lord, so far Muslim law is concerned, my lord, they may have under it may be permissible, but now things to be considered, to be seen is that under CCS conduct rule also, even if it is a permissible under the personal law also, if person is working as a government servant, he has to take a permission saying that it is under personal law, it is permissible, I may be allowed to go for second marriage. But whether that has been done or not, if it's not done, then again the legal complication will come, and there are series of judgment on this aspect also. And regarding whether the second marriage name is enlisted in the nomination in the service book or not, that's under CCS.
That is not there.
That's not there.
Admittedly, that is not there.
That is not.
yes.
Only thing is that those things can be considered later on.
Yes, yes.
But I mean, as far as the maintainability of the repetition, do you have any objection?
My lord, that part we can consider later part.
Some of the prayers
Only-
he has made, grounds he has made, those are not under writ petition. That
My lord,
I've
that's
seen.
right.
Those are only, but only thing is that he's claiming this pensionary benefits.
On,
And he's claiming that he's the second wife.
yes, yes.
Now,
That we can consider later on.
the-
My only point, my necessary party has not been made as a respondent. That is one account important, my lord. Otherwise, without necessary parties, writ
because
petition may not be made.
DMO is the concerned officer.
Yes,
Lordship,
DMO and
Lordship, we
director
have talked with
auditor.
the DMO, Lordship, we have talked with the
Why don't you
DMO.
allow, why don't you allow the other counsel to complete? Why are you interfering?
Hmm.
Court cannot hear two counsels together, right? You just wait
Okay,
for
Lord.
some time, let him complete, then you will come, you submit. Yes.
My lord, for complete
I think he has completed. Lordship.
instruction, DMO, district medical officer, Longding is a necessary party, and as well as the director audit and pension, because this ultimately all this clearance has to be done by the director audit and pension. But here, director audit and pension is not a party here, my lord. Accountant general, this may not be necessary party, but the audit
But
director,
ultimately pension will be,
Yes.
the fund will be coming from accountant general.
madam, director audit and pension, madam, it's necessary.
Direct
Ultimately,
audit and pension.
yeah, director audit and pension. DMO and director audit and pension.
Yes, Mr.
Yes, Lordship. Lordship, we talked with the DMO, Lordship. The DMO said that we have already forwarded the application. We have no
No,
any
no, that
word.
is not that is not the, whether he has forwarded, not forwarded, that is a different thing. He is a
Yes,
necessary
sir.
party, you have not made him a party. And this accountant, director of audit
And
and
pension,
pension, you have not made them party. Then without making
Okay,
them
I'm
party, how
writing.
you are petitioning? Huh?
Director, okay, I will file a affidavit, Lordship, next time.
No, you'll have to file a fresh petition. Affidavit
Lordship-
will not do, you'll have to implead themselves. And you'll have to
Yes.
file a fresh
Lordship,
cause title.
if necessary, may I file the affidavit, Lordship, in the, to
Only
implement
affidavit will
a-
not do it. You will have to file an IA first, then your IA has to be allowed, then parties will be included, then only if this matter can be heard. Those are necessary parties. You have not made them parties. You do one thing, you withdraw this and file a fresh one. That will be better for you. That will save your time.
Okay, Lordship. The second party, he said, Lordship, director, auditor.
Director audit and pension. Director,
Director of audit and pension, he is the ultimate guy who
Yes.
will give you the pension, and you have not made him party. And the person who will be
Okay.
processing the papers,
said DMO.
you have not made him party.
Okay, Lordship. Lordship, immediately I will file it.
Heard, Mr. Your name?
M. Rahman. Mizanur Rahman.
Heard Mr. M. Rahman, the learned counsel for the petitioner. Also heard Mr.
T. Tagum,
T. Tago, the learned
standing counsel for health and family welfare department.
learned standing counsel for the health and family welfare. The learned counsel appearing for the petitioner submits that he wishes to withdraw the instant application because of there is a mistake in making the relevant parties to file the instant the petition afresh. Prayer is allowed. Prayer is allowed. The instant petition is dismissed as withdrawn
With the liberty, Lordship, too.
with the liberty given to file afresh.
Lordship. Obliged, Lordship.
Item number 11.
Your Lordship, in this petition, there are some technical difficulties.
Hmm?
Technical defects are there.
Hmm.
So I may be withdraw to this petitioner.
Withdraw.
Yes, sir. To file a fresh with
You
liberty.
are Mr.
T. Nega.
Mr. T. Nega, the learned counsel, appearing for the petitioner, submits that there is some mistake in instant petition to file a fresh. Where is allowed, the matter is dismissed with the liberty given to file a fresh.
Only one.
Item number 12.
May I, Lordship, please? Lordship, I am praying for adjournment. Since the conducting counsel has left this court due to some health issues.
Okay, I heard Mr. So-and-so, the learned counsel appearing for the petitioner, he submits that the conducting counsel
Kindly,
has
Madam, repeat
has left the court due to some health issues. Therefore, he prays for adjournment of the matter and prays for listing of the matter when?
10 10th March, Lordship.
10th March.
Yes.
10 March is no single bench, division bench will be there.
10, 11 Lordship.
Okay, 11 March.
Leave it up.
Item number 13.
Yes.
Okay, ma'am. Also, this is the GST matter, wherein the petitioner is the proprietor of a firm, their GST registration.
Your GST registration was cancelled
Yes,
and you cleared all the dues, but it has not been renewed.
No, that's it.
Then we'll issue a notice and why
Yes,
you have not renewed?
Lordship,
Yes.
Lordship, there are a series of similar matters taken up by the Guwahati High Court.
Yes,
I would like to,
there are some orders passed,
yes.
similar, I mean, non-renewal,
Yes.
non-renewal.
Exactly
Okay,
similar.
okay.
And such matters have been also disposed in the motion.
Motion
state
stays only.
Yes.
Okay, let's see.
For lots. Lots of days. Now.
Hmm? You are carrying a wrong order or what? Okay, Mr. Counsel, I mean, similar cases has been disposed of.
Yes, Lordship, but here there is need of review. So until unless that there is a direction from the competent authority. So there is need to review this.
No, what review?
Review in the sense whether this GST 3B, which is annexed over here, that has been filed or not.
Lordship, direction may be
That's all.
given to.
In short that,
No, I mean, why so did, I mean, unnecessarily keeping it pending?
okay,
No,
then,
no, what is the difference between the case that has been handed over
yes.
to this court and this case, the facts are
Exactly the similar
Yes.
case.
similar?
No,
What-
there is no issue, Lordship.
Then there is what review is required.
No, review in the sense, since they had filed yesterday and I received in more this copy, then
You wanted to look into it.
yes,
You haven't gone through the petition.
yes, actually, just I scheme now.
I mean, you have received the petition, you haven't gone through it now. What do you want?
But
And the similar order has been passed by the
yes,
court.
anyway, if as per that, if it's
Lordship,
same similar order can be passed also.
Lordship,
Yes, no.
the petitioner can be directed to present one application and the concerned authority can review and consider the
No,
application.
that obviously, that will be that easy.
Yes, Lordship, with direction.
So within 60 days, you're supposed to consider, I mean, approach.
Yes.
The similar order will be passed. You're right. Huh? But Mr.
A Gamre also.
So and so, and also Mr.
T keeper for CGST.
You are standing counsel of
CGST CX Itanagar, Commissioner.
This is another petition. The instant petition has been filed under 226 of Constitution of India, challenging the order dated 31/12/2025 under Form GST, all capital of Form GST REG 19 passed by the Superintendent Namsai Range, CGST and SGST Department, Arunachal Pradesh, through which the GST registration bearing GST IN number 1, 2, capital, all capitals, ASPPH 5411 D1Z8 of the petitioner was cancelled with effect from 31/12/2025. The petitioner's case is that the petitioner has been engaged in the business of execution of work contract in the name and style of Messrs. Mismi Takin Enterprise, a proprietorship firm, and the petitioner has been complying with the provisions of relevant acts and rules by discharging his tax liabilities as and when due. However, on 31/12/2025, the GST registration of the petitioner was cancelled by the Superintendent Namsai Range, CGST and SGST Department of Arunachal Pradesh due to non-filing of returns for continuous period of 6 months. The learned counsel appearing for the petitioner submits that in similar situations and similar facts, several cases have been disposed of by coordinate bench of this court by orders on various dates. One of such order passed in the case of Sri Pankaj Mohan versus Union of India in bracket WPC 7342/2025 bracket complete, decided on 18/12/2025 is placed before this court. The learned counsel further submits that the petitioner being not very conversant with the tax laws, tax and with the CGST and SCGT laws, and due to certain medical emergencies in the family, he could not file the GST returns in time. Full stop. Therefore, he submits that since similar order has been passed by disposing of the writ petitions by a coordinate bench, this matter could be also disposed of at the motion stage itself. Full stop. The above submission is not objected to by the council, by the standing council appearing for the CGST.
Yes.
CGST. Full stop. It is the case of the petitioner that you have paid your, where is the statement?
In para,
Initially received a so-called notice, right?
yes.
Or then when did you pay it?
On
Page-
19/2/2026.
Page,
Page
page
7.
6, right?
Yes, paragraph 11.
Yes.
Paragraph,
It is the contention of the petitioner that on receipt of a digital show cause notice dated 15/11/2025 issued in official online registration account of the petitioner, requiring him to show cause as to why he shall not be required to furnish the returns to discharge his resultant tax liability, comma, the petitioner on 19/12/2026 deposited a sum of rupees 2,71,186 towards the outstanding tax liability. In bracket, you can write CGST rupees 1,35,593 plus SGST rupees 1,35,593. And on his payment, GST PMT dash 06 challan dated 19/2/2026 was issued to him, right?
yes. And also the
The petitioner further paid an interest and late fees of rupees 43,000 and rupees for 3,500 respectively on the same date, that is 19/2/2026. In view of the aforesaid payments, the petitioner submits that since he has already paid the returns, the due returns, and therefore submitted. Therefore, you have filed any application after this?
yes.
When did you file it?
24/02/2026.
What did I write? Last line? Interest, and accordingly submitted a written representation dated 24/2/2026 before the respondent number 3, requesting for reopening restoration of GST registration. However, the same hasn't been done as yet by the GST authorities. Full stop. What do you have to say? You have any submissions to make?
Lordship, yes, as per this proper direction with this order, paragraph 13 of this that order,
Yes.
accordingly, this petitioner may approach the competent officer and after review only, because sometime
Then I'll write like this. I mean, like Mr. So-and-so submits that since similar order has already been passed, a similar direction.
yes,
A similar direction can be issued to the GST authority.
and petitioner also, Lordship. Petitioner, so that they may approach and bring all the record.
That will be
Yes.
done.
Yes,
Direction can be issued to GST authority for consideration of the representation and accordingly do the needful as per the law.
yes, Lordship.
Okay.
Yes.
In the case of Pankaj Mohan Supra, the coordinate bench of this court has considered the case of Dheerghat Hardware Stores and another versus Union of India and 3 others in WPC number 5944/2025 and Mr. Masuk Ahmed Walvia versus Union of India and 3 others in WPC number 6674/2025. After considering the facts of the aforesaid cases, the following paragraphs were reproduced while deciding while passing the direction in the case of Pankaj Mohan, full stop. Then you can quote this from here, huh? Here 10 to 14. Now you can coming back to the case and considering the orders passed in the aforesaid case of Pankaj Mohan and taking into account the issue and the facts in the instant petition being identical, this court is of the considered opinion that the aforesaid decision passed by the coordinate bench of this court in Pankaj Mohan case squarely covers the instant case, and as such, a similar relief could be given to the petitioner as paid for by the petition. Full stop. Then you can write, accordingly, it is directed that accordingly, the petitioner is directed to approach the concerned authority, CGST authority, concerned CGST authority within 60 days from how many days you want? 60 days or lesser than that?
Lordship, it depends.
He can file. I don't think he needs 60 days to file the approach.
No, it's not required. It's not.
Then he do one thing. Yeah. Shall approach the concerned authority within a period of 30 days from passing of this extent order for restoration of his GST registration. Full stop. If the petitioner submits an application and complies with all the requirements as provided in proviso to Rule 22 CGST Rules, 2017, the concerned authority shall consider the application of the petitioner for restoration of GST in accordance with law and shall take necessary steps for restoration of the GST registration of the petitioner within a period of
Lordship, it depend on the review, because sometimes what happened, the concern range that's SP is from NAMSAI, and the review.
how much time will it take?
It will within the 60 days it will do. If possible, it may take around 1 week only.
He is suffering. I mean, like
Yes, Lordship.
I mean, you are also not getting probably.
Definitely, Lordship. We are also only.
It is getting pending. And
Yes,
because he doesn't have the registration number.
Yes.
It's better if you do as soon as possible. You'll get revenue.
Definitely, Lordship.
Then why do you need 60 days? Within a period of 30 days.
Yes, that will do.
He will make it 15 days. Within 15 days you approach.
Yes.
With an application, you don't need that much of time. And 30 days you decide. After receipt of his application, within 30 days you dispose of his application and do the needful.
Because Lordship, in some cases, what happened? There is a digital one data is there, easier data, that sometime due to some technical defect, that opening part, revocation part is to be done by the SP, concern range SP, but the review is to be carried out by the commissioner office, that law means SP. So during that
It will give you 45 days, not more.
Yes.
I mean,
Yes.
It's not required more than that.
Yes,
45 days, okay? 45 days. And make it 15 days. 15 days he will approach, 30, make 15, and within 45 days you decide. What is this section 7310 of 1010 of CGST?
73.
For part payment. Where the
But you have cleared all the amount.
yes, Lord.
So this will not come into place.
This will not.
Yes, that will not come into test.
It is regarding portion of.
Okay, in this case, actually, he did not clear it.
Yes,
That's
Lordship.
why
Yes.
that order was
Yes.
passed. So in your case, you have already cleared it.
Yes.
That's why after review, everything can be.
Okay. So you can
Revocation
write
can be done.
it till that point only. Then you can write in the next para, in view of the aforesaid direction, the instant petition is disposed of as allowed.
Value of less.
High level law.
Item number 14.
Yes, my lord. I am for the petitioner. And as per last order, 8/12/25, the respondents are directed to file their response. But till date, I have not received any affidavit of opposition.
Who is appearing? Who is appearing for the other side?
Lordship, in this case for SGST that previously MK Boro was appearing. So I need instruction from him since I have not been instructed to appear in this case.
Last day, who appeared?
For CGST, MK Boro, Lordship. Because I have not been informed regarding brief regarding this.
Through VC only last time.
Yes.
Last time,
Yeah.
Boro appeared from VC.
Yeah.
And
He's also CGST standing counsel.
previously he was working as a junior assistant. Yesterday I had worked with him and he told me that he has been empaneled in the Assam, this public prosecution part. So he has resigned this CGST duties.
Okay, Mr. Dasgupta.
Yes, ma'am.
It seems the council has, resigned already. The other council who appeared in the matter, he has resigned, and new council will appear. So he doesn't have any instructions. So we'll have to give them some time.
Okay, sir. Okay, madam.
Heard Mr. N. Dasgupta, London Senior Counsel. You
Tita.
assisted by Mr. T. Tara.
IT. Yes, Tata.
T. Tara, the learned counsel for the petitioner. Full stop. Mr.
T. Kipa, Tanya Kipa.
So and so appearing for
CGST CX Itanagar.
all the respondents.
No, actually I don't have, Lordship, I don't have.
You are
that.
appearing for, you'll be appearing for respondent number 2, 3, and 4.
Might be, I don't have petition, Lordship.
And I just go give him the.
I have already served the copies earlier. One, 2, 3. Yes, 2, 3,
2, 3, and 4.
and 4.
2,
Yes,
3,
yes.
4.
Correct.
Commissioner CGST, Assistant
Yes,
Commissioner, Itanagar,
appearing for
and
2,
Commissioner.
3,
Yes.
and 4. 2,
Yeah.
3, and 4 submits that in the instant case, submits that in the instant case, Mr. R. Boro was appearing on behalf of the CGST. However, he has resigned. He's resigned.
Yes, yesterday he,
And he has been told that he has resigned from he has resigned from the empanelment from the standing council of CGST. Therefore, Mr. So and so prays that he should be allowed some time as he has put in appearance anew in the instant case. Full stop. The learned counsel for the petitioner will serve him a copy. One copy will do.
Lordship, yes, because even in this regard, I have no instruction to appear also. Because
What is to be done?
that's why I need instruction from the
Okay.
commissioner office.
Then
So
you write he needs instruction as to appear in the instant matter. So he prays for some adjournment, some accommodation in the case.
yes,
Prayer is allowed and let the matter be listed even.
after 4 weeks.
No, 4 is
Yes,
2 weeks, my lord.
No, but they'll have to file in, they'll have to
Yeah,
file
they have
one,
to have to file the affidavit.
affidavit also.
And
Affidavit
then
also.
I'll file the rejoinder, if any.
Yes. So he'll have to first get his instructions whether he can appear. Then he has to intimate his department.
Yes, Lord.
Anyways, we can put it after 2 weeks. Then you can take the instruction whether you can appear or not.
Yes,
And if you can appear, then you can file an affidavit within
Yes.
2 weeks or so.
yeah, that will also,
That will save some time.
yes.
Let the matter be listed after 2 weeks. After 2 weeks.
Specific date may be given, my lord.
On 23rd of March.
Okay, much obliged, much obliged.
23rd of March. Let the matter be fixed on 23rd of March.
23rd.
Hallelujah.
Matter number 15.
Mr. Das, before you start, I think there was a matter, similar matter
Yes.
was listed yesterday. And in that matter, some instructions was to be submitted.
What
before
was
this
that
court by-
matter, my lord?
Huh?
What is that matter?
That was also same, this this is a forest, reserve forest, right? Proposed
Yes.
reserve forest. The same case.
I'll
mean,
just point out 2-3 things, my lord.
mm.
My lord will kindly see the last order of this court is on 3/3/2026.
But that I have seen.
The lordship has seen the order.
Yes, I have seen it, but only thing is that because it's same matter, a similar matter has been filed yesterday, and notice was issued, and they were saying that, I mean, the preliminary notice was issued for reserve, for declaration of the reserve forest.
Yes.
But the final order was not passed as yet. Till now, no final notification was issued as yet. So Additional Advocate General was intimating this court that the process was going on for publication of the final notice. So this court, after hearing him, this court has asked him that you produce, I mean, you give proper procure proper instructions and intimate the court whether that has been done or not.
But for us, there is a difficulty in this case. I don't know about that which package, because this is package number 3.
And there was a package number 3.
I don't know, my lord, which is the package?
It seems
Which is the
number three.
package number 3?
Mr. Tony
Highway,
Patin,
same
Mr.
highway?
Tony Patin appeared.
Same highway?
Same highway.
Highway package number 3?
Package, I think the same.
Because, your lordship, I have looked into the affidavit that has been filed by the NHDCL, the DC also. The biggest problem in this case, if they have gone ahead, because there is a coordinate bench judgment of this court, coordinate bench judgment of this court, and it says that if there is a preliminary notification which is issued under Section 5 of the Assam Forest Regulation Act, which in this case they have passed in 1977. Now, when it is passed in 1977, there has to be a final notification. In this case, we have made an RTI, and in the RTI we have annexed, and there stand in the court also they said there is a no final notification has been issued by them. So issuing of a final notification is under Section 17.
17, yes.
Not only 17, they have to follow all the procedure that has been laid down under the Assam Forest Regulation Act. It starts from 5 up to 17. Now, let us say today they issued a final notification under 17. This coordinate bench of this court said by issuing only under 17, that is not only suffice. It has to be completed from Section 5 up to Section 17. Otherwise, what will happen, they cannot say that proposed reserve forest is good as a reserve forest. Their stand is that because all the affidavit has been filed, and they have their case, my case is a bit different. Maybe the same, but now the affidavit has come.
Because it was yesterday only.
Yes.
It was the same package.
But the problem
The
was
villagers are also, I think maybe they are different villages, but the same road and for this reserve, same reserve forest, only proposed reserve forest.
my lord, I have no problem. Tomorrow if they come also,
No.
and if they see what will happen, my lord. Now,
Only thing is that like, now if
now
we get
suppose
this
today,
matter, then to,
no, I know, my lord. The problem in this case is that the construction is going on.
process is going
The problem is the Jirat. That's the whole case. That's why your lordship will kindly see. It has been mentioned in this court. There is also one order passed by this court. And the court was asking by virtue of that, when I argued the matter before the court said, what is the status of the land? And they say status of the land is that their construction is going on. Now the problem is land, there is no problem. Tomorrow, if the court finds that it is my land and this has not been done in accordance with the provision that I have laid down, even then I am entitled to get position. I am entitled to get compensation over land. But what about Jirat? This is the whole problem. Land means, my lord, once it is starting constructing they are taking away my the oranges, fruit gardens, the trees.
Same with the
So what? So what will happen?
Same with the other case. They are also claiming for the assets and all these things.
Then this will be a big problem, my lord.
Now, what is to be done? You just give me a solution, because yesterday only we issued notice. I distinctly.
But that is a very.
What was the matter? Mr. Tony Patin appeared in the matter.
But the problem is that
Still government.
I don't know. That may be a very new case. But the problem here is that in this, I don't know, my learned friend, when you are there, you know what is.
Yesterday the matter was there. I mean, you were there. Yes. Mr. Partin, Tony Partin was there in the matter, and Nabam was additional advocate general, he appeared.
But
No, he said that the construction was going on, but till that point of.
yes, what has happened? Because a long stress, it's a long stress. Maybe it's a highway. He may not be aggrieved by because because the construction is going on. I think his part has not yet arrived, that part. So he may not be aggrieved as such, because once it comes to his part, then he will be highly prejudiced. Now my part already started. My lord, this case, kindly see, this is of 2025. There was an order which was passed by this court. Kindly see the interim, the first order which was passed by this court. See the order that has been passed by this court is on 9/12/2025. We approached this court on 9/12/2025.
Their initial order is.
Yes, initial order. Please see the initial order 9/12/2025. My lord, the problem is here that today if your lordship finds that there is no notification. Now let us say for the hypothetical, for argument's sake, 17 is produced before the court. 17 has been produced before the court. But the fact in this case is they said that till today there is no final notification. How, I don't know how the additional advocate general has said that they are going ahead or the preparation is going on.
They say, I mean, they say that the process is on for final notification.
Now, my lord,
Maybe.
if that be the case, because your lordship believes of the council, that's the always. Now the problem is that I ask my client, you get an RTI. The latest RTI says there is no final notification. How they can say, or the RTI should have said that some process is going on. Where is that? Kindly see.
The notification is not there, that they have admitted, but they say some.
No. What will happen, my lord, suppose everything is done. And today, under law, it is found that it was not possible also. The problem is what now? My lord, we are the clans. Now your lordship, in the state of Arunachal, it is not necessary that you have to stay there. We may, for agriculture purpose, we may cultivate also. That's what. We may stay in some other place also. Here is a case where we justified ourselves that census, report of census is there where it originated. It is not a fact. They are not saying. What they are saying in 1977, there was a preliminary notification under Section 5. And they are saying that 50 square kilometers, they are going to likely to be excluded for the villagers. But what they are saying now in their affidavit, they said that there is no question of provision for excluding that 50 square kilometer also. Section 7 is also, how can we issue?
Notification that was there.
Yes. How can, and my RTI, please see the RTI. We got in 2026. See that affidavit reply for a moment.
Just a second.
Yes.
Yesterday's order, I'll just have it.
Yes, I'll just read that. Oh, yesterday's order.
Yesterday's order.
Please.
See, he says, I mean, this was, he said, Mr. Nabam, however, submits that petitioners have indirectly challenged the delay proposed reserve for his notification issued way back in 1977. That was his submission. Then he fairly submits that though process of issuing notification of the delay proposed is ongoing, the same is yet to be finalized.
No, like the problem is,
that was his.
I don't know. Now what will happen? Suppose everything is over, then nothing remains in this case. Suppose, see, I also know these are construction work, but our right should not be affected.
Yes.
Our right should not be affected. That's what we are before the court. Now please see the on page 685 for a moment. 685. Affidavit in reply See, because there is a pagination, so I think that will be no problem. 685.
You've managed.
Because zones of February.
You want the revision?
2025. It will. Please see first 678.
So in your case, this case, you have challenged that notification.
No, we
You have
didn't
not.
challenge. Why will challenge? Because question of challenging is not required also. I will show it. Why it is not? Please 678 for 678. 678.
This is an affidavit by whom?
Reply by
Reply.
yes.
Reply by you.
Yes.
Yes.
Response number 5, NSDCL, I think. No? DC, Deputy Commissioner. See, my lord, 678.
670 office of DFO. Yes.
Yes, see, my lord, 10th of July. See, number 3.
Yes.
Was followed or complied section 6789, my lord, so and so of Assam Forest Regulation by competent authority. If yes, may kindly furnish me a copy of said details. No records available with this office. The DC law it is being requested, provided the same if available. Whether so and so package now passes to Dalai proposed is a yes. Whether any area is excluded so and so, it is excluded from so and so. Now, what we see in their affidavit which are in file, they say there is no question of provision of excluding. There is no question. There is their own letter. I will show it. There is no question of the provision for excluding. Now, please see. Now, please see RTI at page 685. 6685.
Yes.
Number 2. Final notification under section 17 of so and so. Whether final notification under section 17 has been issued.
Not issued.
Not issued. Now today, let's say it is issued. 17. It will fall down. That is the judgment of this coordinate bench. Please see the judgment of the coordinate bench. Why I'm saying that under the law, they cannot go an inch also. Please see that judgment. I'll back by a judgment of the Supreme Court also.
The final notification has to come as per law.
No, some final notification it comes. Let's say that.
But final
let's say
notification has to come as per the process.
Yes, as per process. Now, therefore, what they do it hurriedly because their case in their affidavit says there is no final notification. See this judgment, my lord. Para 11, kindly see the facts. This was a case of eviction. Same proposed reserve forest. They want to evict because they want to set up a medical college. Different forests, no doubt. 11, kindly see paragraph 11.
Yes.
Paragraph 11. I think this, my lord, this was not placed, I think, before the court.
This was not.
Yes. From the pleadings of the parties.
No, yesterday it was only more motion.
Yes. This has gone long back. Well, number of the matter came up before this court. Court felt that the urgency is there. That's why I also know my limitation. I also know there are some construction work going on. That I know, my lord. These are important construction work. But your construction cannot go on inch also if it is not backed by any law. If it is backed by law, yes, please go ahead. Absolutely no problem. Now, please see para 11. From the pleadings of the party and document, para 11.
Yes.
This is the facts. From the pleading of the parties and document placed on record reveal following admitted facts and circumstances. Preliminary notification under section 5 of the Assam Forest Regulation 1891 was issued on 8th of August 1967, proposing to declare Pasighat Station Reserve comprising area of 398 acres. Here is a case, our case is 1977, declaring same under section 5. Number 2, after issuance of preliminary notification, a final notification dated 18 October 1980 was issued under section 17, declaring so and so. Now, in this case, my lord, our case is much more better than this case. I respectfully submit that if you see Roman 2, what it says, my lord, it says 1967, final notification 1980. Our case, no final notification. Now see number 3. Though the land measuring is same in both the preliminary notification and final notification are same, yet the boundary described schedule of both notification different. Final notification not covered the area described. 4. After publication of the preliminary notification, the procedure prescribed in section 6, 8, 10, 11, 12, so and so, and 17 of the Assam Forest Regulation, which are mandatory required to be followed, have not been followed. The land of the petitioner is not covered by final notification. 6. Petitioner have been dwelling in the area covered by preliminary notification much prior to issuance of the same. Several government establishments are there in the land covered by preliminary notification, and land is also being allotted to establish a medical college thereon. So this is the facts. Now, in view, see the reasoning, in view of this indisputable factual position, there appears to be substance in the contention so made in the petition by petitioner. The preliminary notification dated 8 April 1967 under section 5 of the Assam Forest Regulation Act 1891 lost its significance as the area covering so and so which are being proposed to declare as reserve forest was not followed by a final notification after due consideration of formality so prescribed under section so and so of the Forest Regulation Act 1891 covering the same area. Factual proposition remains indisputable. So and so for the petitioner rightly pointed out during his argument. His submission is that with the lapse of time, the preliminary notification dated 8 August 1967 ceases to have any legal existence as sufficient force. Beside the final notification dated 18 October 1980, issued under section 17 of Assam Forest Regulation, declaring so and so as Pasighat Station Reserve, is also failed to withstand legal scrutiny, as it was not preceded by preliminary notification under so and so, and observation of other formalities required to be observed under section so and so of the Assam Forest Regulation Act 1891. The response authority in no uncertain terms admitted area covered by preliminary notification under section 5 and final notification under section 17 of so and so are different. In Annex 8 of the writ petition, which is reply given by so and so. Annex 11, 12, 13 of the affidavit by the response authority makes it very clear. London senior government, Mr. Tapin, also referring to Apple Annex, has clearly stated area covered by both the notification are different, as the final notification under section 17 of the Assam Forest Regulation has failed to withstand the legal scrutiny, same as to be declared void. As a logical corollary, it has to be set aside and quest. Now, coming to the...
That is the law.
So
Correct.
now, if that be the law...
Now in your case,
yes.
In your case, your basic thing is that you're not challenging that declaration.
No, I will not. I am not challenging.
You are only saying that your land has been used in the project, and though land compensation was paid to you, but Gerard was not paid.
No, they have not done anything.
Okay.
What they are saying two things. They are saying that these are is as good as a reserve forest, is as good as a reserve forest. They are saying preliminary notification proposed reserve forest is as good as a reserve forest.
Okay.
So whether you be there or not there, you are not
eligible for anything.
For any compensation.
Because you are residing inside a reserve forest.
That's their case. So you are not entitled.
So
now
you'll have to argue that is not a reserve forest.
This is what, and apparently on the face of it, it is not a reserve forest. It cannot be because there is no final notification under section 17 as on date. Maybe it may come, let us say for argument's sake, after 10 days final notification comes. Then whether you can whether you can continue with the work. How can you continue with the work? That's the whole point. At one point of time, NHTCL has letter is there. They said what you do it. They are right. They said under section 41, for urgency purpose, you acquire the land. Issue notification, preliminary notification, by issuing a notification to the public that this is an urgency purpose, 41, we are acquiring it. But the state government is not. State government is saying what is necessary. I have seen the affidavit which is filed by NSCCL. They were not opposing to it. The problem is with 3-4 letters, which is very tricky letters. very tricky letters.
Yeah, Mr. Das, today we are going to.
No, only the problem.
We are going for a disposal.
No,
or
no, what I am saying, now the problem is that your lordship has said there is another matter, yesterday matter.
Correct.
My only difficulty is today, we don't mind, my lord, but the only problem is that the Jirat, the work is going on. How the problem is that that's why the court has kept. How the problem is that they will not carry the my portion. And if they want, then they should calculate what is the oranges, what are the cardamoms, because tomorrow it is wiped out by them. What remains, my lord? What remains in this case?
So at this stage, what do you want?
So I want that from my portion, they should stop it and they should calculate. After calculating, they let them go ahead. Absolutely no problem. Give a time bound. Within 10 days, within 15 days, 7 days, you calculate. Then you start doing it. Ultimately, end of the day, suppose your lordship finds that this is ultimately that the notification under 17 also, they doesn't follow the procedure. It will go.
In this case, there was no interim order passed, right?
That's why, my lord, your lordship will kindly see, there was an order that was passed by this court. Interim order will be considered. Please see the first order. Please see the order that has been passed on 9/12/2025. See this order.
Yes, yes.
Issue notice of interim prayer. The learner respond an up-to-date instruction to by return on which the interim.
I mean, what do you have to say on the interim?
Your lordship, it's a project of national importance.
No, understand.
Understood. Project years long.
Now, see, thing is that there's another case also.
Yes, your lordship.
Another case also with the similar facts, similar this thing, but maybe that the urgency may not be there, just like Mr. Das's counsel.
Yes, your lordship.
Because maybe like his land is already being taken over. I mean, it's already been.
Yes,
already being used.
Taken.
But the other case, the land is yet to be used. So there is some time they have, but he doesn't have time.
Yeah.
Now thing is that, see, for passing an interim order, I'll have to hear it. I'll have to hear him also, hear you also. Are you ready today? Or Mr. Das, anytime next week can we do? I know like you are coming from outside. Because for the interim, I'll have to hear this.
I know. Can I just start it, then keep it on next on 11? Your lordship can just keep it on 11.
Or both can be finished.
Because the problem is that the construction is full swing. The place has been taken by them. That's the whole difficulty we are facing it. And today, now the progress is going on. Now, what will happen, my lord? How it will be assessed? That's the only problem.
No, we will hear
how progress.
We will hear you on the interim part, because
and they are going, see, my lord, and we have given a photographs on the last occasion also. All the photographs have been produced before the court, and this is what the problem we are facing, my lord. We have annexed all those documents. We have annexed also with our.
So you are admitting now. I mean, you are using. I mean, the land claim by them.
Can I suggest one thing?
Yes, yes.
Can I suggest one thing, my lord, subject to your lordship, my lord? My lord, at least for a week, let them stop and let them. My representative client will be there, NHTCL will be there, state will be there. Let them assess. It is, and let them come with a report on 11th. That this is what we assess, but the other rest, the work they can go on. There is absolutely no problem, my lord. It is only 50 square kilometers. This is the whole problem, my lord. Only 50 square kilometers. Let them come. It will help both the parties. I suggested to the court also, and the court wanted to know what is the status of the particular. Give the status. They said the work is going on. I think that's what my learned friend says. On 5/2/2026, the court wanted regarding the status of the work, which is subject matter. Because I pressed, my lord, honestly, I pressed. I said, what remains in the case? That was 5/2/2026.
Yes, yes.
Kindly see, my lord. And 5/2 and today, the problem is that. And in the one judgment.
You are appealing for whom?
1 to 6 years.
1 to 6. And you? 7 and 8 NHA this year.
See, one judgment of the Supreme Court, continuously wrong day cannot do it, which has been also relied by the coordinate bench in Union of India versus Tarsem Singh, my lord. See that continuous wrong day cannot do it. Then the court will rescue, my lord. Kindly see paragraph 7. See paragraph 7, my lord. This is what is relied by the coordinate bench. Paragraph 7. Maybe it is a claim of seniority, but principle that to be followed, my lord. Paragraph 7. To summarize, normally that was relied by coordinate bench. A belated service-related claim will be rejected on the ground of delay and laches, where remedy is sought by filing a writ petition on limitation, where remedy is sought by an application to administrable. One of the exception to the said rule in case relating to continuing wrong, where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy, with reference to date on which the continuing wrong comments. If such continuing wrong creates a now kindly see, this is important. If such continuing wrong creates a continuing source of injury, but there is an exception to the exception. If the grievance is in respect of any order or administrative decision which related to or affected several others also, and the reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. For example, if the issue relates to payment or refixation of payment of pension, relief can be granted, may be granted in spite of delay, as it does not affect the right of third party. But if the claim involved issue relating to seniority of promotion, etc., affecting others, delay would render the claim stale and doctrine of laches limitation will be applied. Insofar as the consequence relief of recovery of areas so and so is concerned, principle relating to recurring successive wrong will apply, as the High Court will restrict the consequential relief relating to so and so to the date of filing. Now, what has happened in the case of the coordinate bench? Coordinate bench was also even a worse case than us. 17, my lord, notification issued. Section 5, 17 notification issued. Court said, no, you can't. Directly, you cannot jump to section 17. There are certain procedure which you have not followed. Then the court set aside that order. The preliminary order section 5 was set aside. Today, what happened? If they come up before the court saying apparently here admitted position by them, section 17 not followed. What is the effect? No, what is the effect?
Come to section 17. In between, there are other sections.
No, what happens?
So those has to be complied
No,
with.
suppose, let us say, what happens today as on date? Today, now the problem is there may be an apprehension in the mind of the court also. For me also, I am thinking that it is a national importance work. Now they are going ahead. But you cannot continue something wrong on your part and it can continue. You cannot continue, my lord. Some wrong has been committed by you that you don't. There's a letters, I can show the letters. It is admitted position by them. Admitted position. Kindly see, my lord, one letter of the NSDCL. This is the affidavit that has been filed by NSDCL. It starts from 610.
Yes.
They were right first. See 625, my lord. 625. See 625.
Yes.
What they have written? They have written general manager to deputy commissioner. It is requested to acquire 384 so and so hectares to intermediate lane road from so and so
625.
Page 625.
625 para.
Not para.
No,
it is an annexure.
Oh, then the pagination is.
It is
wrong.
633.
My page is
6?
Mistake.
Huh?
633.
My pagination, that's the whole problem.
Maybe it's.
It should be 633.
Yes, 633 is there. Yes.
But my pagination is 625. 633. Now kindly see 633.
Yes.
Requisition of land acquisition requiring body for construction. Correct, my lord?
Yes.
It is to requested to acquire 384.90 hectares of land for construction of intermediate lane road from so and so, and the details are furnished along with 3 copies. Now kindly see 2. It is requested land acquisition for the subject project may be done under so and so an urgency clause under 41 with exemption from any additional component to be invoked for acquisition of land considering defense strategy and national security point of view, it is certified that land to be acquired or demarcated on the field and all further necessary information and necessary provided on the date, time appointed stipulated by you. But this was not adhered by the state government. They did not issue any notification under section 40. My lord will kindly now see at page 628, 634, 36. 636, my lord. This is what DFO has written to the executive director. Lordship got it?
Yes, yes.
Yes. As per the information furnished by a letter, so and so proposed alignment passes to Dalai proposed reserve forest of Lohit so and so. Now,
No, Mr. That's what I'm suggesting is that, see, this matter will require some hearing.
yes.
So if you want to do it today, I don't have any problem. You can go ahead with this, provided, I mean, you are ready? Are you ready with the case?
Yes, sir.
If we can dispose it or we can hear it fully, what?
For disposal, no, Your Lordship, because
But I'll
other respondent have to file.
Hmm?
Only the Deputy Commissioner has filed his affidavit, Your Lordship.
Only Deputy Commissioner has filed.
no, Deputy Commissioner NSDCL has filed.
You,
It's all
and
has filed.
pleadings are not
They have
completed
filed.
yet.
Pleading file completed.
I have already filed, madam.
The
All
who
has
has-
filed. I file a reply also.
The pleadings
DC
are,
reply.
I presume that pleadings are completed.
No,
It's
I
not
have also
completed.
filed. DC reply I filed.
All the
DC replied,
respondents-
No, he is
NSDCL
saying
replied.
something, but I mean, is there any, I mean, anybody is not represented or not filed affidavit?
No, I am for the 1 to 6, Your Lordship.
Huh.
But in regards to respondent 5, we have filed, Your Lordship.
Respondent of 5 is who? Deputy Commissioner.
Yes, Your Lordship.
And who else has to file?
Deputy Commissioner is also a forest settlement officer.
Yes, Your Lordship.
So he
And
is
who is
there filed.
appearing for this forest departments?
I am.
He is appearing. He be-
Land management, you are appearing.
Yes, Your Lordship.
You are appearing for 1 to 6, isn't it?
Yes, Your Lordship.
DC also is the forest settlement officer, my lord.
Then who, I mean, you are representing them, then what? You want to file affidavit, more affidavit? For somebody or what?
If necessary, Your Lordship.
If necessary, you'll have to decide. I mean,
Yes,
till
sir.
now, what have you been doing? I mean, this is an important matter for you, important matter for, I mean, yeah, this indigenous people are there. The important matter.
As per our affidavit, Your Lordship, there was a direction to.
No. I mean, see, if you say that we are ready to dispose for the disposal of the matter, we can hear it, or we can hear it for the interim prayer that he has been making. We can hear it, or we can post it in the next week.
May I, Your Lordship, from the suggestion of my senior, Your Lordship, it may be, the direction may be issued for the assessment of the said land, Your Lordship. I think it will be the better position as of now, Your Lordship.
Assessment for what?
The
See,
there are
your
no-
stand is, I mean, I don't know. I mean, of course, your stand is they are not supposed to get anything because it's a proposed reserve forest, correct?
Yes, Your Lordship.
Now your stand is that now you are saying that like some assessment to be done. What does it mean?
It was only after the,
No, what does it mean? That means, are you saying that like that is not a reserve forest? Then the whole case will go now.
no, I'm not saying, Your
No,
Lordship.
you're saying so. You are saying that assessment to be done. Assessment of what? If any assessment to be done there, that means that is not a reserve forest. That is not a proposed reserve forest. Then you're declaring that this is not a reserve forest. You do assessment, and on the basis of the assessment, you pay them money. Is it your stand?
No, not
Then-
exactly, Your Lordship.
Then how can you say that? And how can a court pass? An order which is, which court should not pass.
And I'm sorry.
That we'll think about. I mean, there is a proposal that has come from the London Civil Council.
No, only what I'm worried means is only that tomorrow everything is over, then nothing remains. See, but land compensation, there is no problem. Even tomorrow, after 5 years also.
Now you are
if
worried
they
about those.
yes, land
there are-
compensation one is entitled.
That
But
will that
that I will get it.
later on
That is
also-
why there is an order passed by the court, that we'll get it, no problem. If later on also, later on. But the problem is about the Chirat. This is the only problem. That's why I was mentioning for the court. Court also asked them status report. So if they go ahead, then nothing remains. The only problem is that they could not have gone ahead, my lord. Why they have gone ahead? There was a lot of repercussion, lot of public meetings, and there was a minutes of meeting where the deputy commissioner said, yes, we will sit together. There will be a cleanse. My people will there. That meeting was cancelled. And they reviewed and they said, no, you are not entitled. You are not entitled for a penny also because it is. Now kindly see what review they have done at page 316.
316.
Please see 316 of my writ petition. 316. What is this, my lord? At page 316 of my minutes of meeting. This is minutes of meeting of 24th of July at page 314. Now please see the last. We were also present.
DFO Lohit.
DFO Lohit clarified about the issue of Dalai proposed reserve. He stated Dalai reserve forest is proposed one without final notification, but it is good as a reserve forest. But in this point it goes, my lord. You don't have to see others. It is their own admission. He explained how is that any kind of development or project under the army or executive district undertaken only after clearance taken by the government. An area measuring is excluded from so and so user will, but with no proper demarcation. They doesn't know also, my.
And Mr. Das, what interim order you are actually?
No, what I am saying, my lord, my particular work, my lord, they cannot carry this work, my lord. It is my stretch. 50 square kilometers, my stretch, they cannot. Let them go ahead with other. Or let them do it, my lord. It is up to them. And today, my lord, will kindly see, it is their own admission.
No, I think we'll have to hear it on interim.
Yes.
I mean, will it be comfortable for you on 11th? Are you there on 11th? Yeah.
11th, I am.
You're here.
Yes.
Still on hear you on 11th.
Your lordship has heard this matter. Keep it as a part-heard, your
We'll keep
lordship.
it as part.
Part-heard, my lord.
Keep it as part.
Because one
Keep it as
matter.
part-heard. On 11th, we'll see. 11th, we are not disposing of on 11th, or
No,
or
it's
we
not
can
by, my
or
lord,
on
two
the
things. Two things. One is your lordship keeps on interim, or if you feel that it can be disposed, you will dispose. Either of these two things, your lordship can take a call.
But if the pleadings are complete, why we can't be disposed of?
Yes, pleadings are complete. According to me, my lord, pleading reply is also being filed.
Oh.
Reply file.
7, 8, and 5 has filed, other.
No, others, I mean,
all
all parties are not required to file. The concerned parties and the linked parties only file. The 11th will take up this matter.
Yes, yes.
And we'll see whether we can dispose of, then we'll dispose of.
Or otherwise
interim also interim. You also come with the preparation with proper instructions.
Yes.
That what is to be done or not, and what is a stand. Okay.
Well, all responsibility I am saying, I know the repercussion of all these type of projects. Any national importance project, court should not interfere. But apparently, if it is on face of it, because after going through all the pleadings I am saying, with all responsibility I am saying, it is their own minutes of meeting. It is the entire one by one I have seen their affidavit and reply. All affidavit I have looked into it. Their own admission, my lord, there is no final notification. What is the effect of it? The effect of it is that you cannot go ahead with that. What is next alternative? A notification has to be issued. The NSDCL rightly said that it is an urgency purpose, that is 40. What is 41? 42 is that 80% has to be paid in advance if it is an urgency clause. So there is no question of any notification to be issued under 40, which is parameter of 17 of the earlier act. If it is for urgency purpose, for army, defense, if it is for that purpose, then 42 can be exercised without issuing any notification. And under 42, 80% has to be paid in advance. Compensation. That's the law, my lord. 80%. There is no question of any award. That's why they said that they acquire it under 42. Government said no. It is a delay for a proposed reserve forest. What you have done, it is your minutes of meeting and you are saying that there is no final. It is as good as a reserve forest. I have not come across. That is why the coordinates bench has set aside that order. saying, how can you say as good as reserve forest? And in that case, it was one step worse than us.
There,
My lord,
there
you
section,
see, my lord.
Section 17 notice was there.
Yes, the court said that also becomes bad because by that time all the procedure has to be followed, and that was set aside. What happens in this case? It will have a cascading effect. If today your lordships sees that merit of the case is set aside, entire project will come to a standstill, my lord. The government has to think twice, my lord.
Yes, I mean,
my lord, this will come to a
Mr.
It will have a very bad effect. I am telling your lordship.
Why, Ram?
Why you are not paying them all these GIRAs? Land is something else that you can decide. But as far as like the GIRAs and all, you should have paid them, I think.
The difficulty is, Your Lordship, in our stand, Your Lordship, it comes under the proposed.
That's why I'm saying, you'll have to mold your stand. You have to do something. They are indigenous people. They're cultivating there. No? They are not. They're cultivating there.
Indeed.
So whatever has been cultivated, if you are destroying those, at least that much something you can.
Difficulty here is, Your Lordship, there is no notification regarding the road project, Your Lordship. So, because we have straightforwardly stated that it comes under the Delhi Reserve Forest area, so no acquisition process will be done.
And I think there are many families are affected. Correct?
There might be, Your Lordship.
There are a lot of settlers probably there.
There may be, Your Lordship. I'm not aware as such.
And even interim order is considered, there has to be some reasoning order in the interim also.
Yeah, absolutely. That's why I'm thinking about. We will need proper assistance from them also.
But today, if they come up and they said in the court, they are assumed that there is no final notification, then I think legally they cannot go ahead with this project also. If there is, because their whole stand, it is a delay for proposed reserve forest. If it is a proposed reserve forest, it is as good as a reserve forest. Then their argument falls down. If it falls down, then where is the question that we are not entitled?
No, I think that this is already settled that if you do not issue a final notification on the section 17, then it cannot be termed as a reserve forest. I think that has been settled.
So now, suppose it is not a reserve forest, can they go ahead with the work?
Can they go ahead without land acquisition, without
Right.
paying this thing?
Correct, that's what.
The question.
So I think, my lord, that's what I am saying. That is a fit case for an interim order also, that they cannot go ahead because one line.
No, that part, legal part is fine, but otherwise, this is an important project for them.
No, that I know. That's what I am
You have
saying.
also submitted.
No, I know, my lord. That's what I am submitting, my lord.
Before passing any order, this has to be given a little bit of thought.
Yes.
And that is why I'm thinking that he should also come up with proper this thing. You come up with proper.
Yes, sure, I'll try.
You come up with proper instruction. And we'll hear on 11th on the interim.
Yes, sure.
Or if required, we'll hear it. We'll see about this, but we'll keep it for interim.
Yes, sure.
Then you'll have to come, with your proper instruction. What is your stand
I'll seek further instructions.
Because it will have some effect and it will have some bearing on the whole thing.
Because by hearing the interim also, it will touch the merit of the case also. That's the only problem, my lord. Here it will touch the merit of the case. Because my argument, I am making it clear so that my learned friend at least prepare on that line. My argument, I will harp on that only. Propose reserve forest. If it is no final notification, automatically it falls down. Then you have to go back again to a notification to issue either under 40 for urgency purpose. Then you have to pay to the owners. 80% has to be paid in advance. If not that also, proper acquisition process has to be taken place. And you have to identify which are the affected person.
This project started when?
This project started somewhere in 2020.
25.
For 24, all correspondents are there. At one point of time, it has come to a halt also. It has come to halt. The people at large also, they put a dharna and they said no. They stopped also. Because one point of time they said, we'll call all the village in a minus meeting they were called. And they said, we'll hold a meeting. A meeting with your clients and the office who has the project, who is NHCCL, and also deputy commissioner.
And
But suddenly they cancel.
What about the environmental thing? It's all cleared. Environmental clear.
Oh, environmental. My lord, interesting. That I know your lordship will ask. See the NSDCL. See this, very interesting. Will be 636, 637, 638, 639. Please see 639 and see the pleading. First see the pleading. 639 and see the pleading. See the pleading at, what is it?
Oh, your page will be different again.
My God, that's why. 621. See 621. Kindly see 621.
Yes.
Before they see the foreign clearance, before para 6,
Hmm.
the foreign clearance for construction work has been received from the Department of Environment of Forest, Government of Arunachal, White, so and so, dated 8/10/9/10/2024. Right, my lord? Correct, 2024. Please see now 630. 639. See the subject.
Yes.
See the subject.
Yes. Construction of so and so.
See package number.
Package number 1.
This is not package number 1. They have annexed a document to show before the court that there is a forest clearance. And this is regard to package number 1. Where is the clearance of package number 3? Please see it, my lord. I may be wrong, but I have gone through it. This is what I find is package number 1 only.
Yes. Yes.
Package number 1. So where is your clearance? This is the whole problem, my lord. This speaks about subject, this speaks about package number 1.
Yes, it says about package number 1.
Then this, my lord, absolutely, these are some statement which is made by you, which is absolutely, it is perjury. You can't make some statement which is totally misleading to the court. When you read this, when I read for a moment, I thought it is package number 3.
No, I think that stress is only to William.
Yes, there.
And there are 3 packages there.
There are 3 packages. Package 1, package 2, package 3.
Package 2.
Our case is package 3. So where is that foreign clearance? You don't have a foreign clearance also. And our is 61 to 125. So there are 3 packages. As I have told that package 1 may be complete also.
And it was not given for the whole road. Clearance was
Yes.
not given, environment clearance was not given for the whole road.
This is package number 1.
For number 1.
And this in package number 1, my lord, foreign clearance was given. Package number 1. But so far as package number 3, there is nothing which has been done by them.
Okay, then we'll keep it for 11.
Yes.
Heard Mr. D. Das, senior, learned senior counsel, assisted by I. Das, the counsel appearing for the petitioners. Petitioners also heard Mr.
Y. Riram.
Y.D.
Riram.
Y. Didam.
Riram, yes.
Didam. The learned standing counsel.
No, your lordship, junior government employee.
Junior government advocate.
Yes,
Junior government advocate for respondent number
1 to 6. Your
1 to 6 and yourself 7. Mr. So and so for 7. The instant petition was listed for admission column. However, the same could not be. However, after hearing the matter substantially, the same could not be completed. Completed, and there was a prayer for interim relief. There is a prayer for some interim relief in the instant case also. Also, therefore, this matter to be listed on 11th as a part-heard matter for consideration of interim relief.
My lord, if I am in legs in one of the matter,
Ah.
please adjust me at 2 o'clock, my lord,
Ah,
if
will do.
possible.
That will do.
Yes.
That will do. And
He'll come for
Mr.
admission column, my lord.
Huh?
He'll come for admission column.
Admission column, it will come for admission column. Admission
Part
column.
third, it will
And
remain so that
it
it
will
comes on top, my lord.
come as part third only. And we'll initially think about the interim, and if required, then like we finally dispose of, then we
Yes.
dispose of. And you intimate your seniors about taking up of this matter. Is an important matter.
Yes, sir.
You intimate. Your own hierarchy you intimate. Okay.
But one thing is very clear, if there is a procedure has been followed, then of course, Mala, I have nothing to say if that procedure has been followed. If procedure has been followed, then nothing to say, my lord, in this case. But they have followed the procedure in package 1. There's apparently they have annexed that document also. Package 1. But so far as the package number 3, of course, it could not have been followed because by their 2026, 16th of February 2026, apparently by when RTI, they said no, we have no final notification has been issued.
But that will be applicable to package 1 also.
I don't know. Who has done, I don't
Maybe,
know.
certain procedures they have followed
I don't know.
package 1, but
I don't know about package 1.
but as far as this notification regarding declaration of forest, reserve forest, that is not there.
Yes. But we have, but my lord, we have not didn't challenge the proposed reserve forest because we not required. Not required. Automatically it will go because once it is there is no final notification, automatically it go. It cannot be as good as a reserve forest. Their whole stand is that it is as good as reserve forest. You cannot make something like a reserve forest and you cannot say as good as reserve forest.
Reserve forest is reserve forest, and there is nothing like proposed reserve forest.
Yes.
Actually.
And it is also, if it is for an emergency purpose, then if it is not done also 17, then they can issue a notice. What the NSA, DCL has said, issue a notice under 42, rightly they said. So there is no, then there will be no question of any notification. Under section 4, I think, under section 17 of the new Clara Act.
Yeah, that is
17.
emergency situation.
Emergency situation. There is no question of any award.
But they haven't done so.
They requested for that purpose.
But they haven't done so.
They didn't want to do it because they said they relied on 1977 proposed reserve forest. Where is the question? And they said 50 square kilometers, what will we exclude to the views of the villagers? Now when there is a letter which has been issued by Deputy Commissioner to the DFO, then what do you want to say on this? Issue an NOC. Then I'll show that letters. Those letters, he said that what you are saying, these 50 square kilometers, whether it falls under 387 entire square kilometers, which you have given, whether I am not very sure, he said, that whether it falls 50 square kilometers also falls under that 387 stretch. He said, how can I issue that? I cannot issue. And how can I issue that an NOC? I cannot issue an NOC. And there is a letter, they said that by any stretch, we cannot issue any NOC in this case. Where is today also that 50 square kilometer they could not identify. They could have identified. They themselves said RTI that no, we can't identify with that 50 square kilometer.
Yes.
They have to follow the process. Then they can identify it.
Correct.
I am deeply obliged, my lord.
So we'll hear it on 11th. Today it will be difficult a little bit. So
I'll also look into it, certain judgments of this, because these are, I am telling my learner, these are important projects.
The important project, they also come with some preparation so that you can also assist the court. You intimate your people also and take instructions. This will, the order is passed. Any order passed by the court has some impact but in this matter, this kind of matters, there are certain personal matters that doesn't impact the society as large. But in this matter, there are a lot of people are involved. This is a public project that will be stalled. NHIDCL is involved. Their work will be hampered. So a lot of stakeholders. So in this kind of cases, I think you guys should be prepared.
My instruction is that what I have received through my instructing counsel that package 1 and package 2 also payment has been made.
Payment has been made.
Yes, we will show that if necessary. Payment also has been made in package 1 and package 2. That is over. package and
The
one
payment
package.
to whom?
Affected families?
Or they have already,
Yes. There is a notification. They have issued a notification there.
then why
Right.
you are not?
Yes, that's the whole point.
That is not, that is.
Because they said it is falls under the proposed reserve forest.
Huh. No, but that package 1 and package 2 doesn't fall. Huh?
No. This is stress.
But it is the same stress.
Yes, they didn't.
But
that didn't
different,
fall.
different stresses.
Yes.
But
different.
yeah, but only package 3 falls under
Package
the same.
3, they said, Delhi forest is a forest. I have to go back and I have to again verify it.
I have to verify.
Yeah, I have to verify
But
it.
otherwise they are, or maybe because package 1 they have taken this thing,
Yes.
environmental clearance
Yes.
and all.
There are certain procedures.
But package 3,
Suppose
I mean,
other-
if package 1 is not falling within the that proposed reserve forest,
Yes.
then environmental clearance would have been more important for 3 rather than
Yeah.
1.
100%.
Then I don't know how.
Yes.
they are doing it.
Normally, under the Indian Forest Conservation Act, 1988, there is some procedure how that clearance has to be given.
Correct.
Under that 1980 Act.
That is also, that's a totally different
88.
aspect. Whether the state government can directly give it or not without
They
consulting.
cannot. They cannot. These are all a procedure has been laid down.
It's a forest,
It's a way.
forest land is
Yes.
union. Forest land is union
Yes.
is involved.
No, all I know, my lord, in this area like Itanagar is our entire forest land, all this. Under this, the system procedure is completely on a different footing altogether. Compensation are not being paid like we pay. The payment is being made on the basis of the what is the value of that land next to. Here is on a manual is there, manual 2022. They rely on manual 2022 when compensation is given. If it's a horticultural land, they will pay on the basis of that.
That one.
So they will pay on the, if it is a Zoom land, they will pay the value of the land on that particular, it is already there in
So
manual
if it's given
2020.
in the manual on the basis of that, they'll.
Yeah, they will pay. They follow the Lara Act, but payment is not as per Lara Act. Well, Lara Act, they say that yes, we follow 2013 because there is a gazette notification.
There is an.
Gazette notification in 2000 because now acquisition in state of Arunachal, maybe there is a Balipara Act where acquisition section 10. But 2013, when this act came, the Lara Act, they notified. There is a gazette notification by the state itself. They said whenever a compensation is to be paid, we will pay compensation under section 26 onwards, under Lara Act. Even because if you see, minus section 10 of the Balipara Act, it is a reasonable amount assessment is being made and amount compensation is paid.
So
Under the,
nothing to do with market.
but you're nothing to do with market value. Reasonable assessment has to be made. Now, it is a beneficial legislation. Whichever is high, you have to pay. So they say 2013, there is a gazette notification. They have issued. Suppose under Balipara Act also, it is acquired. It is not that the payment will be made under the Balipara Act. Payment has to be made under the Lara Act. This is their notification itself.
Oh.
But now the problem is Solicim also has to be paid. R&R policy also there. If it is a community land, if it is a clan land, then that benefit they get it. So all these procedure are different here, my lord.
I mean, but according to the customs, they may have
Yes.
customized it.
Right.
To basically extend help to them.
Yes, right.
Oh.
And this what your lordship is, it is a clan land. The community, clan land. So when it is a wide forest also, they do go and cultivation of land takes place.
Oh, that is.
They
earn
earn their livelihood from them, from there only. It is not necessary that I have to reside. I can go there, do my farming here and go back. But now here system is that when it becomes a community land, maybe it's an open space, I go and community stays there. It becomes a community land. But if it is a reserve forest, then situation becomes different. Then all the procedure has to be followed.
And in the reserve forest also, otherwise, otherwise in the reserve forest also, the indigenous people can go there for lot many things.
Yes.
Lot many things, small cultivation, then picking up firewood.
Yes.
Those are allowed. Certain things are allowed. We'll hear it
Yes.
at 11.
Yes. Clear, please.
Matter number 16, May I please, Your Lordship?
Hmm.
Lordship, this is in bail application.
Hmm.
Regular bail application. Based on grounds of non-compliance of notice and non-compliance of ground of arrest.
And we'll have to issue notice on this.
Yes, Lordship.
We'll have to call for the CD on this.
CD, Lordship, it have already been called, Lordship. Last date, it have already been called.
Already?
Called. CD has been called, Lord.
Ah, whether CD is there?
It's there, Your Lordship. My assistant just took the file away. I think he misunderstood that the case has been over. If
Okay.
Your Lordship just pass over this matter for time being, Your Lordship.
Okay. You are challenging what basically? Violation of
Non-compliance of notice under section 35 clause 3, Lordship, DNS 2023.
35 clause 2 is what?
And non-compliant, serving of notice to the accused person while arresting.
35 is a arrest memo.
No, under
Section 40, 47 is not giving the grounds.
under BNSS, Lordship,
Section 35 is what? Arrest memo.
when police may arrest without warrant. Yes.
So it's a arrest memo. The arrest memo has to be given to you.
No, arrest memo is Lordship provided, but under some Supreme Court guidelines, this recent judgment has passed. So it has
That is 47 and 48.
47 and 47 or 48 also not complied in this matter, Lordship. While
That has
arresting,
to be seen. But the 35.2 is what? 35.2 is different.
the 35 clause 3, Lordship.
Clause 3 is what?
If your Lordship permits, may I read it?
No, no, 35.3 is, one second. For notice to appear.
Yes, before arresting, when the offense is under punishable for under 7 years of imprisonment.
Okay, I will let them come.
Oh, right.
Matter number 17.
My lord, service report is still awaited in respondent for respondent. So this matter.
Respondent number 2.
Yes, my lord. One is single respondent is there, my lord.
Okay, service report, service of notice on respondent number 1, on the respondent is still awaited. Let the matter be listed after a week.
Matter number 18.
Lord, in compliance with the order dated 02 to 2026, an affidavit has been filed.
So it will be, I mean, it will be listed for listing. And an affidavit regarding respondent number so and so. Paper publication has been filed.
Done.
So it is ready for hearing.
For a hearing.
So, I mean, as per the right, I heard Mr. So and so, and counsel appearing for the petition. Petition, yes.
Has to be now proceed ex parte.
Hmm?
This has to be now ex parte proceeding has to be.
Let's see. I mean, we'll fix it for hearing. Then if they come, then they'll appear.
And so far, this substantial question of law has not been plain.
That will be done when the matter will be taken up. This is only for order. Heard so and so. As per the office note dated 27/2/2006, 2026, an affidavit regarding service of notice upon respondent number through paper publication has been filed by the learned counsel on behalf of the petitioner. In view of the aforesaid, let the matter be listed for. It will come for what? Admission?
Admission, yes.
Let the matter be listed for admission. Let the matter be listed for admission on when? Make it on 24th of March.
Okay.
Matter number 16.
Can copy has come?
Yes, Your Lordship.
The same matter or what?
Pardon, Lordship?
Same matter it was called.
Yes, just 61 bail hearing, Lordship.
Yes, yes. I mean, what is your ground? I mean, you are saying that 35 3 is not complied with.
Your Lordship, yes, 35(3) BNS 2023 have not been complied when the arrest was made. And again, such written grounds of arrest also not complied by the concerned police department, Lordship. Till date, there is no any intimations or regarding this notice and grounds were served.
What is there in the case diary?
Your Lordship, we have served the copy as well as the arrest intimation as well as the
Yes.
ground of arrest was also given, Your Lordship.
Show me.
Also, the statement under 180 has also been recorded, where in fact he has disclosed that even on the earlier occasion, he has done the same offense, Your Lordship. He was arrested and he was on bail. But due to, since he had no other works, Your Lordship, he again got involved in forgery of the ILP, Your Lordship.
Forgery of?
The
Inner line
the
permit.
officer
Alleged
concerned
accused
for
offenses.
issuing of the inner line permit, Your Lordship.
May I, Lordship? Lordship, if I may allow, regarding the topic we just have this, PP have just regarding the said things that just recently, just PP have informed about the anti-criminal antecedent. I would like to.
No, wait. First, let me see this. Your name is what? Abu Hanifa?
Yes, Lordship. I'm the Abu Hanifa is the accused and applicant is the Asraful Alam, Lordship.
Asraful Ali is the applicant.
Alam Asraful.
He is not involved in this case.
He's not involved, Lordship. He's the nephew of this accused, alleged accused person.
Why are you saying section 35(3) will be applicable? In this case, arrest is not required.
Some recent Supreme Court judgments have been there, Lordship.
No. Why arrest is not required in this case? What is the allegation against you? Against the allegation is you have been involved in.
If your Lordship may permit, I would like to read out the FIR, Lordship.
Yes.
Kindly see the page number, Lordship. Yeah, page number 19, Lordship. This is the zero FIR, requesting for registration of zero FIR, which was lodged by one Miss P. Mary Boy, presently serving as Circle Officer UPL under the Deputy Commissioner Papumpari District, which to lodge a zero FIR concerning the discovery of a forged inner line permit issued in my name with a fabricated signature and falsified office seal. Point number 1. I recently obtained a copy of an ILP that appears to have been issued from the office of the Circle Officer, Dari Leparada District, AP carrying my name, Arunachal Pradesh. Official designations and a forged signature, although I have been posted at Papumpari District since November 2023. This clearly.
You were behind the bars for how many days?
49 days, Lordship. And Lordship, I have already moved this, before also I have moved bail applications and CGM at Alo, Lordship. So that order also, annexed here in this petition, Lordship, I mean, application.
If you, if the forgery of inner line permit is very, I mean, it's not a small offense. Arunachal Pradesh is strategically located. A lot of people are coming, a lot of people are going, and a lot of problems are happening in your place because of that. And if somebody who forges this inner line permit, then it will be a big issue, having a lot of impact in your society. But he's already spent 49 days.
Yes, Your Lordship.
Lordship, regarding the alleged offense, I'm not challenging the offense or the what to say investigation, Lordship. It will be the matter of trial.
Ms. Genie, 49 days. Offense is also forgery, this thing.
Forgery of the signature of the concerned authority, Your Lordship. Your Lordship will see in his statement, he has stated that.
No, I mean, that I have seen.
Investigation is also at the stage where other of the co-accused is to be arrested, Your Lordship.
Co-accused is there?
It's there, Your
Where?
Your Lordship will see that accused are.
The FIR is against whom? FIR is against.
There is no particular name in the FIR.
You wait, you have submitted, you wait, we need to understand. I mean, you just don't keep on saying, okay, whenever there is need, then only speak. Then it's better, court will understand better. And you'll get a good order. So let the court understand, okay? Yes, Ms. Zini, I mean, who is the co-accused?
There are three co-accused, Your Lordship. Abu Hanifa is one of the accused.
Yeah.
He was arrested on 19/1/2026, Your Lordship. He is still in the custody.
So Abu Hanifa is the present applicant, right?
Yes. No, Your Lordship. This is.
No, he is the one.
Right? Yes.
Abu Hanifa is the accused who is languishing in jail recent
One
right
is
now.
Abdul Khadir, Your Lordship. He was arrested on 15/2/26, Your Lordship. One is the co-accused Mofidul Islam. He's still absconding, and he is the main person along with whom this accused presently.
I mean, we cannot get a grant you bail at this stage. I mean,
Lordship.
this is a very. I mean, the crime is not a simple one, and other accused are not arrested as yet.
Lordship, this offense is a documentary offense, Lordship. Then, and the accused is.
But the offense is very sensitive.
And it is.
Mr. So-and-so, the learned counsel appearing for the accused applicant also have the learned counsel APP for the state. This is an application under so-and-so, you write. Then write an FIR, and FIR was lodged on. FIR was lodged on which date is this?
May I, Lordship?
FIR was lodged on 27.
Dated 27/11/25.
27/11/2025. Before the officer in charge, Doimok Police Station, Padumpare District, by one P. Mary Bui, APCS, Circle Officer Upia, Padumpare District, raising that it has come to her notice. He or she? P. Mary?
She, Your Lordship.
It has come to her notice that there is circulation of forged inner line permit issued in her name with fabricated signature and falsified office seal. Also, in view of the aforesaid, the FIR was lodged to do an investigation into the matter. Full stop. After investigation, police arrested. After investigation, police arrested the accused applicant along with another co-accused.
Abdul Khadir, Your Lordship.
Abdul
Khadir.
Lordship, the same has been released in the day itself. After the.
Yes,
The same that the Abdul Qadir have arrested on the same day at Lakhimpur and brought to Basar PS by the concerned police department. But the same is released before producing to the court. That
Your Lordship,
Abdul Qadir have already been released in the same day, Lordship.
Your Lordship will find in the status report, Your Lordship.
So
The only
verity
reason
also may be
it will
considered,
released-
Lordship.
The only reason for him to be released was on medical ground, nothing other.
He's 70 years old.
Yes,
person,
yes.
Isn't it?
56 years old, Your Lordship. His statement was, however, he was arrested and released on medical ground, Your Lordship. He's a diabetic patient.
Another co-accused was arrested. Arrested, but the aforesaid co-accused was released on the same date by police because due to the medical, due to certain health issues. Full stop. Full stop. The learned counsel obtained for the accused applicant submits that since the accused person has already spent 49 days and 49 days behind the bars, he should be allowed to go on bail at this stage. On the other hand, MSTGNI, the APP has submits that the issue involved is very sensitive as fake inner line permit have been issued in the name of the second officer. So stop. If she further submits that the investigation in the instant case is yet to be over, as the main accused in the instant case is yet to be arrested by the police. Full stop. In view of the officer, she opposes the payer of bail of the accused applicant of the accused person in the instant case. Full stop. And this court has heard the submissions made by the counsel appearing for the respective parties, has also gone through the case diary that has been for a scanned copy of the case diary, which has been produced before this court. Having perused, having considered, after considering the entire facts of the case and entire facts of the case, this court is not inclined to grant bail to the accused person at this stage. In view of the aforesaid, the instant bail application is rejected.
Lordship, liberty may be provided for another bail petition.
But that you can always do. That is always there. That you can always do, but at this stage, no.
Applied.
It's a question of inner line permit forgery. I mean, Arunachal Pradesh is a strategically placed state. A lot of people are coming here without any authority. This is not good.
Matter number 19.
My lord, if I may, the service report is waited, my lord. On
Service
report,
Service report in respect of respondent number 2 and
2 and
3
3, this is still
is
awaited.
still awaited as per the office note dated 25/2/2026. Let the matter be listed
On 2 weeks, my lord.
after 2 weeks. Okay.
Platform.
Matter number 20.
Lordship, in this case, there is no interim order. On the first day of motion, it states interim order. Hearing for interim order was on the next returnable date, but the party not appeared on the next returnable date. But we have taken steps.
You have taken Dusty.
Yes.
So it will be placed before it is placed for admission. If
yes.
Dusty has been served.
Yes.
Heard Mr. Titapak, the learned counsel appearing for the petitioner, also heard.
Sir, respondent number 7, sir.
You are appearing.
Yes, sir. Yeah, on behalf of
Respondent number 7.
learned counsel, Jibam, sir.
Respondent number, Dusty was served from whom? Respondent number 7.
7.
Okay. Mr. So-and-so appears on behalf of Mr. So-and-so for respondent number 7.
I'm for the state, Your Lordship. 125, Your Lordship.
Mr. MS So-and-so for appears for this respondent number 125. This state. Okay. Let the matter be listed for admission.
Yeah, Your Lordship, we have not filed our counter affidavit, Your Lordship.
We file it. I mean, it will be listed on 24th.
Your Lordship.
It will be listed on 24th, and in the meantime, you file your counter affidavit, or you take your time.
On that next date, fixed, Lordship, interim order is required, Lordship.
No, that will be considered on that.
On that day, Lordship.
Yeah, Lordship.
That may be recorded.
No, that's not required. I mean,
Lordship,
already our order is passed already.
Lordship, I was directed by my learned counsel for seeking 2 weeks of time for filing the affidavits, my lord.
You have already it will be listed on 24th. So we are getting 2 weeks almost. How much time you are getting? You are getting 2 weeks.
If the matter doesn't dispose, Lordship, matter may be consideration of interim order, because this is a land
Because
compensation matter.
order
If
already has been
money
passed.
release,
Now thusly you have
Yes,
he has appeared to press for the interim, interim order in the next day.
yes.
Already a judicial order has been passed. So there is no requirement of passing the same order repeatedly. Okay, already is passed.
Any order.
Matter number 21 and 22.
Lordship, item number 21 is IA, Lordship.
Hmm?
Lordship, 21 is IA in main writ petition, Lordship.
So you have to issue notice on this. On the IA.
May I please, Lordship? Lordship, I'm not in party in IA, but I am party in item number 22 in writ petition. And I have filed one caveat, but this caveat has been not listed because the basing which they are relying the IA document on that against I have filed a caveat, but today that has been not listed.
But then if you have filed any caveat, then how this matter is listed without, registered without giving you any copy?
Lordship,
Because he has not made me party. He has made only to the
No, Lordship.
department.
Lordship, that actually I had to complete my submission, Lordship. Sorry, Lordship. Lordship, that there is technical problem because there are two orders. There is for the group A and group B. Now we have only annexed the group B, whereas there is also a group A promotion. So, Lordship, we have not annexed the required document. So I may be allowed to withdraw, Lordship, because I have
Okay, withdraw for which one? IA.
yes, Lordship, with
Then-
liberty, Lordship, because
With liberty and have a copy to him also, he has filed a caveat.
Lordship, actually, regarding this, it was filed by the order passed by the state government because there was no any need to be filed caveat by the respondent because he was
No,
not.
he is filing the caveat. State government also he can file caveat.
I'm
right?
just saying,
If he thinks that like he should be heard before, he thinks that he may be aggrieved by any order passed by the court. So he wants that he should be heard before party. So that can be done.
Lordship, however,
Any order, heard Mr. So-and-so, your name? Agra?
G Kata.
Huh?
G Kata, Lordship.
On the Catalan Council. Okay, for the appearing for the applicant in instant IA. He submits that there is some error in filing of the IA and pays for withdrawal of the IA. There is allowed, IA is disposed of as dismissed.
Lordship, with liberty, Lordship.
Hmm?
With liberty to file a press, Lordship.
Then you can file it.
That's it.
There is no problem.
And Lordship, this is one this is main writ petition, Lord.
Main writ petition, you will be listed after 2 weeks.
it was
You
Lordship,
filed the IA.
already in main case on 24th of February, this matter was again, it was listed. This Honorable Court has given 3 weeks to file the affidavit on 24th of February.
And-
They had filed one previous IA and that has been disposed. This was the second IA. On that date,
So why are you not filing the affidavit?
Lordship, this
You are the respondent.
no respondent
No,
is the
I'm the
Lordship.
respondent.
Thing
Who
is-
file affidavit?
We are filing.
Why you are not filing then?
This Honorable Court has given 3 weeks time on 24th.
No,
We
no.
are filing.
No,
we are
no,
filing.
Lordship.
Okay,
This is
okay, wait. Let both these matters be,
Lordship after 1 week, Lordship.
let the matter be listed after a week.
Lordship.
This and this along with the connected WBC. Along with the connected WBC. In the meantime, the respondents are at liberty to file their affidavits in opposition. Okay.
That's it.
We file them.
Oh, let's see.
Matter number 24.
IA is disposed of as withdrawn, and this repetition to be listed after a week.
May I please, Lordship? Lordship, this matter may be listed on 30th of this month, Lordship.
On the prayer of the learned council, so and so, let the matter be listed
On 30th for disposal, Lordship.
on 30th of March. None appeared for the respondent, I think.